Why can't you hear nothing?
All right. Good morning, ladies and gentlemen. My name is Judge Lal, and we are going to begin with the state all-purpose calendar. This is with the Fulton County State Court. Today is June 15th, 2023 at 9 a.m. I am going to be going over these misdemeanor cases to determine the status. This is a calendar for individuals who've been formally accused of misdemeanor offenses. They have already had their initial appearance, bonds have been set, and hopefully counsel has also been appointed to represent them. Today, it's essentially what we call a plea and arraignment calendar. If the defendant wishes to accept a recommendation from the prosecutor, we will have a plea hearing in which the defendant will then enter a plea of guilty or no contest in exchange for the recommended sentence offered by the prosecutor. Otherwise, the defendant also has the right to enter a plea of not guilty, and the case will be further noticed for trial. Other matters I may address include bond modifications. If you are a defendant charged with one or more misdemeanor offenses, please remember the following. You have a right to remain silent. Anything you choose to say during the course of these proceedings, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we will have a counsel from either the public defender's office or our conflict defense list to represent you. Okay, I have Ms. McLeod. You have quite a few cases. We will try to get to those. Mr. Kilbo, you have, I believe, position 3, if I'm not mistaken. Do you have any other cases?
No, just position 3, Marcus Clark.
Okay. And courtroom 2, is Marcus Clark in courtroom 2?
Your Honor, this is ACDC Officer Milton.
Yeah.
I would like to do position 31, Wilkerson. And
yeah, I'm going to do 31 first.
But I would like, the reason I want to do him first is that I can go and get the females.
I see. Okay. I'm just calling out for Marcus Clark so that we may have Mr. Clark available as well as soon as possible, since Mr. Kilbo has only got one case. All right, let's address position 31. Is this Mr. Cherie Wilkerson? Debbie Moulton, is that Mr. Wilkerson?
Yes, ma'am.
Okay, Mr. Wilkerson, I'd like to remind you, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and this morning representing you is going to be Mr. Michael McLean. Do you see Mr. McLean on the screen? He's waving his hand at you.
Yes, ma'am.
Okay, good. That's going to be your attorney, and he's going to be speaking on your behalf.
Yes,
Mr. McLean, what are we doing in this case today?
It turns out this is a negotiated plea. We were able to speak on the phone extensively. I went over the plea statement questions the court might wish to ask him. So we've been over every bit of that, and we've also been over the case itself.
All right, thank you.
Asked the court to accept his negotiated plea of guilty, and he stipulates to jurisdiction, which is venue, and a factual basis and identification.
Thank you. Thank you, Mr. McLean. Mr. Wilkerson, I understand that you have spoken with your attorney and that you wish to enter a plea of guilty to the charges in exchange for a recommended sentence. May I place you under oath? The other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Jones, good morning.
Good morning, Your Honor.
And what is the recommendation for Mr. Wilkerson?
The state's recommendation is going to be 12 months to serve, 288 days, credit for time served, 134 days, balance suspended, and a stay, well, this incident took place, in a stay away order.
From where?
1 second, Your Honor. I was unaware that it took place at the.
You know, maybe I was reading, thinking it was a typo. I was thinking 268 days is double 134. Is it the state's intention to offer him time served, balance suspended because he's been in so long?
That is not the state's intention, attorney.
288 days divided by two would be.
He'll have 10 more days, I believe.
I'll talk to him further.
Okay.
Your Honor, we may need a breakout room at some point, and I'll explain to him about.
Is Mr. Dodis's laptop up and running?
Yes, Your Honor.
We have come to rely on that laptop quite frequently, so it's going to be a permanent fixture of SAP. So as soon as Mr. Dodis's laptop is open, I can place Mr. McLean at that laptop with AC/DC in a breakout. Mr. Jones, any particular reason why we are seeking the additional 10 days as opposed to a time served?
Your Honor, if we can pause on that moment, I'm going to reach out to Mr. Walker to see if we can make this amendable, if that was a typo.
All right. Please reach out to Mr. Walker. Deputy Milton, we just need to hold on for a few more minutes. And Mr. McLean, we will get to Mr. Wilkerson as soon as Mr. Jones returns. Deputy in courtroom 2, do we have Mr. Clark available?
Yes, he's here. Okay, come on, Mr. Clark. That is position number 3, Mr. Marcus Clark. Go ahead and have a seat.
Marcus Clark is position 3 in the calendar, case number 20 CR 0000973A, accused of battery, family violence. Mr. Clark, you've been advised of your right to remain silent. Your attorney is Mr. William Kilbo. Do you see Mr. Kilbo on the screen? Mr. Kilbo, if you could just wave your hand in front of the screen. Mr. Clark, do you see him?
Yes.
Thank you. And Mr. Kilbo, how would you like to proceed with the case today?
Your Honor, Mr. Clark would like to enter a non-negotiated guilty plea.
All right, have you reviewed the documents with him with regards to his waiver of rights and so forth?
I have not reviewed the documents, but I did discuss the rights that he would be giving up and the consequences of entering a non-negotiated guilty plea with him yesterday. And he has given me permission to sign the documents on his behalf.
All right, okay, we will proceed. Mr. Clark, we're going to proceed with a non-negotiated plea hearing, which means that the prosecutor is going to give me a recommended sentence if you decide to plead guilty, and your attorney is going to give me an alternative recommendation. I will then decide which recommendation I will accept, keeping in mind that I have a right to deny either recommendation and set this case down for trial. Ms. Bickerstaff, good morning.
Good morning, Judge. How are you?
I'm doing good, thank you. And
Good.
what is the state's recommendation, please?
The state's recommendation is 12 months to serve 60 days, credit for time served, 3 days, balance probated, and FVIB, no further contact with Joshua Garmany, and to stay away from 515 Mill Road.
Is that in Atlanta?
Yes, Your Honor.
Thank you. Mr. Kilbo, what's your recommendation?
Your Honor, we're asking for time served and the balance suspended. we're asking they not be required to do FVIP. I think Mr. Garmany is on the call. I think I'll give you some background and then if Mr. Garmany could speak, but this incident occurred in 2020.
Mhm.
Mr. Garmany and Mr. Clark are not related. They're not in like any kind of relationship. They were, I guess, met in the neighborhood. And at that time, Mr. Clark owned the house at 515 Dollar Avenue. Since that time, and Mr. Clark's 59 years old, about to turn 60. His family had lived there for a long time. In 2017, this incident occurred in 2020. 2017, Mr. Clark lost his father. 2019, he lost his sister. Then he had two autistic brothers living with him, and he was caring for them. And his mother passed in 2021, and his two brothers passed in 2023. And he's lost the house to foreclosure, which those circumstances led to him missing court, which is why he's back before Your Honor now. The 3 days of time is he did 3 days the very first time he was arrested on this case. He subsequently in 2021, he was arrested.
Yeah, I do see his additional charges, yes. And he spent an additional 85 days on that other case.
Yes, and then you see that case was declined to prosecute, which
Yes, the felony charge was declined. I see that, yes. But he does have the other open case for battery.
This is that case.
Oh, yes. All right, I see that now. Sorry.
Okay, so he spent 3 days plus 85 days plus he's been in since I think June 3rd now.
Mhm.
And so he's done about 100 days.
Okay. Let me speak to Mr. Garmany and see if he wants to. Unfortunately, it may appear that he may have. Mr. Garmany is Joseph Garmany, I believe. I saw him on the Zoom, but Mr. Garmany apparently has stepped off. Okay.
Your Honor,
Yes,
may
Ms.
I-
Bickerstaff.
yes, I misspoke. I didn't mean to say credit for time served 3 days. I meant credit for time served 30 days. So it would be a time served, but still balance probated to an FBIB, no further contact and a stay away.
All right. So the point of contention appears to be the FBIP classes.
Your Honor, the reason I'm asking for no FVIP is that this is not, I think Mr. Garmany was staying, I see his name has reappeared on the screen if he wants, if Your Honor would like to hear from him.
Yes.
But they're not family. They don't live together anymore. It was at that time that Mr. Clark had allowed Mr. Garmany to stay in the house. And further, Mr. Clark, because of his age, he's on disability, has very limited income, and has been staying at the Peter Street Baptist Mission. So I think it's going to be very difficult, if not impossible, for him to complete. It's going to be very difficult for him to complete FVIP.
Okay. Thank you. Mr. Joe, did he fall off again? Yeah, I don't think he's got yeah. All right. Ms. Tyson, other than we're looking at position number 3, since 2021, after 2021, have there been any other arrests for Mr. Marcus Clark? Other than the bond forfeiture?
After 2021, give me 1 second.
Scroll over and display the date.
No, you're not after 2021, no.
All right. I will accept the state's, the defense's recommendation. It will be 12 months to serve 60 days, credit for time served 30 days. Mr. Garmany, if you can start your video before we lose you again.
Yes, can you guys hear me?
Yes, I can hear you. Can you start your video? Okay, good.
Yes,
All right.
Yes.
Are you Joshua Garmany, who was involved with the Marcus Clark case?
yes,
All right. Do you have any objection to Mr. Clark being released from jail today?
No, please let that man go. Y'all making a big mistake, man. That man done lost everything. He's an old man, and he did me a favor by letting me move in. And he ain't got no business in this right now. I made a mistake.
All right. As I was saying, I'm going to accept the defense's recommendation. It's going to be 12 months to serve 60 days, credit for time served 30 days, balance suspended, and no further contact with Joshua Garman, and to stay away from 515 Dollar Mill Road in Atlanta, Georgia. Mr. Kilbord, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Mr. Clark, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Okay, you'll need to speak up. Okay, sir?
I swear.
All right, thank you. Mr. Clark, have you consumed any alcohol or medicine recently?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Are you entering a plea freely, willingly, and knowingly?
Yes, ma'am.
And you're giving up your right to a trial before a judge or jury to confront your accuser, to challenge the evidence brought against you, and to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of battery, family violence?
No contest.
Repeat.
No contest.
Mr. Clark, I think we discussed you were going to enter a guilty plea.
Guilty.
I accept your guilty plea. Your sentence is 12 months to serve 60 days, credit for time served 30 days, balance suspended. And you are to stay 200 yards away from Joshua Garmany and not contact him in any way, form, or manner. Do you understand, sir?
Yes, ma'am.
All right, this matter is closed. Thank you.
Thank you,
Thank
Your
you,
Honor.
Mr. Kilgore. Have a good week.
Take care, Your Honor.
You too. Thank you, Mr. Garmany. You're free to go. Mr. McLean, are we ready to conclude with Mr. Wilkerson?
We are, Your Honor.
Okay. Let's find out. Let's find out from
yet-
Mr. Jones. Let's find out from Mr. Jones. I'm sorry to interrupt.
No problem.
Mr. Jones?
Yeah. Yes, Your Honor, we are willing to turn it into a time serve offer.
Okay, so do y'all have to tell me, what are the numbers? 12 months to serve how many days?
Mr. McLean, do you have those days?
Well, doubling 134 would be 268.
268.
Okay, 12 months to serve 268 days, credit for time served 134 days, a balance suspended, and to stay away from the incident location. Would that be correct?
Correct.
Yes, Your Honor. The incident location is going to be 1155 La Vista Walk.
Okay. Mr. Wilkerson, have you consumed any medicine or alcohol lately?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And has anyone forced you to take this plea today?
No, ma'am.
And has it been explained to you that if you decide to plead guilty to the charges, that you would have to give up your right to go back to court, to have a trial in front of a judge or a jury, to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass, trespass causing damage to property, and loitering and prowling?
Okay.
How do you plead?
I guess to. Guilty. Guilty.
I accept your guilty plea to these charges. Your sentence is 12 months to serve 268 days, credit for time served 134 days, balance suspended, and do not return to 1155 La Vista Walk in Atlanta, Georgia. That's the place where you were arrested. You cannot return to that location. Do you understand?
Yes, ma'am.
Thank you. That concludes this case. Deputy Milton, I think we'll just wait until you bring the others in, okay? All right, thank you. Courtroom, jail court iPhone. Yes, sir. Who do we have there, please?
Position 27 and 28,
Thank you.
Mr. Ray.
Mr. McLean, I believe that's your client, Quintavious Ray, who's prepared to take a negotiated plea. Would that be correct?
Your Honor, that is correct. These
All
are
right.
two separate matters. They have identical
Charges?
charges and identical recommendations. And I've explained to him that the math could be this or that, but he's in jail on another matter at any rate. So he's asking the court to accept his negotiated plea of guilty while stipulating to the three necessary elements of venue, identification, and factual basis.
And you do stipulate to the factual basis for both cases, correct?
We do.
All right, so Mr. Jones, there's no reason to allocate the factual basis for these two particular offenses. And I'm going to waive sounding on the two particular offenses. Mr. Quintavious Ray is charged with a misdemeanor offense. They're the same offense for positions 27 and 28. The case numbers respectively are 23 CR 1474J and 23 CR 1774J. The first incident allegedly occurred on February 23rd, 2023. The second incident occurred on March 5th, 2023. Mr. Ray, you have a right to remain silent about the facts of the case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. Jones, may I have the state's recommendation for both cases?
Yes, Your Honor. So the state's recommendation for the case ending in 7-4J is going to be 12 months to serve 90 days. And then the state's recommendation for the case ending in 7-4J, it is again 12 months to serve 90 days.
Are they concurrent?
They are concurrent.
All right, and is he being given credit for any time served?
No, Your Honor.
Your Honor, the offer did not state a credit amount, and because he's in jail on a continuous basis anyway on another matter,
Okay,
I marked it down on my, during my analysis, I marked it down amusingly to myself with quote, calculate it yourself, unquote.
okay.
But I was
Understood.
satisfied and I discussed it with my client. He's satisfied.
All right. Mr. Ray, could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
All right. And Mr. Ray, you understand that this is going to be a guilty plea to the two charges, correct?
yes,
And you know what those charges are?
yes, ma'am.
All right. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes,
Mr. Ray, if you decide to accept the plea offer from the prosecutor, you would be serving 90 days to satisfy your obligations for both these cases. You would also have to give up your constitutional right to go back to court to have a trial to challenge the charges in these two cases. You will have to give up your right to confront your accuser, have the assistance of counsel to challenge the evidence brought against you, examine witnesses, present any defenses you may have, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
You understand that this will conclude the case, these two cases, and that you do not have a right to appeal.
yes,
How do you plead to both the two charges in these two cases?
guilty.
Your sentence is 12 months to serve 90 days. After the conclusion of serving 90 days, both these cases would be closed and concluded. Any remaining time is suspended. Thank you.
Thank you.
Position 20, Lester Harris.
Mr. McLean, this is Joshua Ahmad Lester Harris, hyphenated. I understand this is going to be an arraignment. Would that be correct?
That is correct.
Okay. This is case 23 CR 03528G. Mr. Lester Harris has got multiple counts, 7 counts of theft by receiving stolen property, a misdemeanor offense, and 1 count of criminal trespass, allegedly from June 1st, 2023. Mr. Lester Harris, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, do you waive a reading of the accusations?
We do.
Okay. Mr. Lester Harris, you have been charged with 8 separate misdemeanor offenses. Each offense could carry a separate sentence if the case goes to trial, and you are found guilty if the state carries its requisite burden of proof. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, as I indicated, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted of 1 or more offenses and be sentenced to up to a year in jail and or up to $1,000 fine for each convicted offense. Such sentences could be served separately or they could be served together. Given this information, how do you plead?
Not guilty, Your Honor. Good morning.
I accept your not guilty plea. The case has been arraigned and it's going to be further notice for trial. Mr. Lester Harris has currently got a bond in this particular case. The bond was set on June 2nd for the amount of $8,000. It's a split bond. I'm not certain what portion of it is.
I can inform the court. He has
Looks like $1,000 surety bond.
That's correct, Your Honor. He has a $1,000 surety bond on the 1 count of criminal trespass. All the other counts are theft by receiving because of items of identification or whatnot that was in a bag nearby. He was accused of squatting in an apartment, and problematically, that'll be something that it may be best to deal with in the trial court. I recommended to him, and he recommended to me that he was interested in being free. He's from North Carolina, a little town called Oxford. I talked to his grandparents on the phone. While in college, he was a counselor. He was a worship leader. He was in a religiously oriented college called Montreat College near Asheville, North Carolina. He tells me he does not have an arrest record. So even though the bond at this point is, quote, merely, unquote, $1,000 surety bond, the grandparents, not being Georgia residents, cannot go to a bonding company and sign for him. The only option he would have would be to come up with $1,000 cash. Well, since he's accused of squatting in an apartment, he comes to Atlanta to seek his fortune. And he's accused of squatting in an apartment, which is, we will discuss that later. I will discuss that later with him, and a trial attorney will. But Your Honor, he doesn't have $1,000 cash. So as a practical matter, he says, didn't know what was in that bag that was nearby. So that's going to be his defense at trial. So we would ask the court to consider giving everything. And if he is correct that he doesn't have an arrest record, we would certainly implore the court to give him a signature bond on that remaining surety.
Ms. Tyson, this is position 20. Any prior arrests or convictions for trespass or theft?
No GCRC record was found, Your Honor.
All right, thank you. Mr. Jones?
Yes, Your Honor. Just very briefly, I know that counsel kind of went over the facts a little bit, but the bag was not found near him. The bag was found on him. It was a fanny pack in which, when officers knocked on the door, the defendant opened the door and came out, and upon a search incident to a lawful arrest, officers found the fanny pack, and inside of the fanny pack were the seven cards. In addition, the defendant advised officers that he received the Georgia driver's license that he had and a debit card from a female friend who stole them from a vehicle break-in. So again, we are concerned for this defendant's behavior. So we will ask that the court keep the bond as is.
All right. I'm going to, I was going to ask Mr. McLean, I hate to be a nosy Parker, but what next then for this young man? I mean, he's from North Carolina, he's here, he's homeless, and what's the next step then, if I let him out on the street?
Let me confirm what my conversation was.
Because I don't think he's welcome back to Camellia Lane.
Going back to Oxford, North Carolina with the grandparents, getting a job, which he's sure he can do, making enough money to hire a private practice attorney. If he can't make enough money to hire a private practice attorney, show up in court on time and ask to use the public defender here.
All right. I'm going to amend the entire bond to an $8,000 signature bond through pretrial telephonic reporting only. Ms. Tyson,
Yes, Your Honor.
he'll be interviewed at the jail, and at which time he will provide us with his grandparents' address and phone number,
Mhm.
or he has 30 days to update the court and pretrial with that information.
Can he give it to his attorney right now, and his attorney can, Mr. McLean can put it in the
Yes, I
chat?
believe he can,
If I
because
can-
Mr. McLean has spoken to the grandparents.
Your Honor, if I can lean over to my copy of the calendar, let's see, this is number 20. Okay.
Yeah.
So I flip back one page, Your Honor. In Odyssey, that 4 digits and that 4-letter name for that road in Oxford, North Carolina, is that the correct address? It's spelled G-E-L-A-G. Right. Your Honor, the Odyssey is correct. 3018. There's a name of a road that's 4 letters long and is spelled correctly. It's in Oxford, North Carolina. Odyssey has the correct zip code. On
Okay.
page 2 of Odyssey is listed as emergency contact, which the jail oftentimes asks for in addition, we ask for. So
Does Mr. Lester Harris have an email and a phone number?
let's see, he's got 2 grandparents and the phone number that is listed.
No. Does he have it now? Is that something he can provide you with?
Do you have an email? Yes, sir. I do. Okay.
Mr. McLean, anyone born after 1990 is born with an email address. So,
Thank you.
yes, we will need his email address, and he can put that in the chat to A. Tyson at pretrial.
Yes.
And as I said, it's going to be an $8,000 signature bond through pretrial services. If he changes his address, he must update the court, the clerk's office, pretrial, and his attorney.
Okay, you're listening carefully to all these points, right? Yes, sir. Okay. Now, the thing, Your Honor, when I talk to young people, I always ask them, if you don't check your email every day, just don't even tell it to me, because if you don't check it every day, it's useless doing it. But that's fine, Your Honor. He's got an email.
Very
here.
sage advice, Mr. McLean.
Is that
He would need to report to pretrial telephonically once a month. If he misses any of his telephone report calls, pretrial will suspend the signature bond and issue a pretrial bench warrant, which means that we can have Mr. Lester Harris arrested for failure to report in North Carolina as well.
right?
And we'll need a good mailing address so that we can send him his notice of when to come back to Georgia for his next court date.
Okay, we got
And
a good.
without saying, he needs to stay away from the entire complex at Amelia Lane.
He will, yes. Sir.
Thank you.
Excuse me, Judge Law, is that going to be $1,000 for each count?
Yes, it's $1,000, 8,000 signature bond through pretrial telephonic reporting, mandatory requirement to update addresses and phone number and contact information. All right, thank you.
Thank you, Your Honor. Thank you, Your Honor.
And don't forget to put the email address in the chat for me, Mr. McLean.
I can do that.
Thank you.
Get that keyboard, sure.
Position 29 spells.
Okay, good to meet you. I got it. Okay. That's an H.
This is State versus Raquel Covette Spells, position 29, case 23 CR 3533F. Mr. Spells was accused of loitering or prowling, giving false information to an officer, and theft of lost or mislaid property. Mr. Spells, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea. Mr. Spells, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge? Thank you. Mr. Jones, what's the plea recommendation, please?
Yes, Your Honor. The state's plea recommendation is going to be 12 months to serve 45 days, credit for time served 15 days, balance probated with an anti-theft course, 40 hours of community service, and a stay away from 2135 Piedmont Road.
Is that the Home Depot, the Target, or the Best Buy? It might not be either. I'm just guessing.
Goodwill parking lot.
Goodwill. Yep. it's
Oh, Goodwill. Okay.
That's a parking lot, yeah.
And Mr. McLean, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
He does, and we do.
Thank you. Mr. Spells, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea today?
No, ma'am.
Has it been explained to you that if I accept your plea, that you would also have to give up your right to go back to court and have a trial
Yes,
to
ma'am.
be able to confront your accuser, challenge the evidence, challenge the testimony from witnesses, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay. How do you plead to loitering or prowling, giving false information to an officer, and theft of lost and mislaid property?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served 15 days. You have, I think, 5 more days to serve at the jail.
Something like 5 or 8. The calendar itself didn't have certain information, but we were thinking it'd be about 5 or 8. We were thinking 45 is rounded off for this division purpose to 46, half of which is 23, minus 15 days would be 8.
I'm thinking it's 5 days, but I'm going to let the jail make that calculation since they're the ones who offer the 2-for-1. And so Mr. Spells, like I said, you will be spending a few more days at the Fulton County Jail. I believe it'll be anywhere between 5 to 8 days. Is that your understanding?
Yes, ma'am.
All right. Well, for you, I hope it's 5 days because once you're released, you have to report to probation. The probation office is located at 132 Mitchell Street. You have to report within 7 days of being released from the Fulton County Jail. Do you understand, sir?
Yes, ma'am.
And once you're released and you're on probation, you will need to complete an anti-theft class. And for the places where you do the class, probation will advise you as to which school you can go to do that class. You will also need to complete 40 hours of voluntary community service at any nonprofit agency. And you may do so at, well, I was going to say Goodwill, but I don't know about that. So you can do it at any other nonprofit agency like the Atlanta Food Bank, Salvation Army, Animal Rescue, and so forth. Do you understand?
Yes, ma'am.
Okay. And unfortunately, you will have to stay away from the Goodwill store at 2135 Piedmont Road in Atlanta, Georgia.
All right.
All right. Okay, that concludes this case. Thank you.
Excuse me, Judge Law,
Repeat.
what charge will the 40 hours of community service be for?
This will be a concurrent sentence for all 3 charges.
Okay. So it doesn't matter.
Thank you.
Did I already get on the contact information?
Yes, sir.
Okay. I think I'll find it. Thank you. I remember writing that down.
Positions 34 and 35, Wilson.
What's our President Wilson? Is he got 40?
Mr. Wilson is accused of disorderly conduct in case 20 CR 4980J from January 28th, 2020. Mr. Anthony Wilson is represented by counsel, Mr. Mike McLean, and he has been advised of his right to remain silent. Second case is a bench warrant, case number 23 FTA 472 for failure to appear from court April 26, 2023. Mr. Wilson, I understand this is going to be a negotiated plea for the disorderly conduct charge. And if the plea goes forward, then the state will dismiss the bench warrant matter. Mr. Wilson, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
Thank you. And Mr. Jones, what is the recommended offer?
Yes, Your Honor. The state's offer is going to be 12 months to serve 26 days, credit for time served 13 days, balance suspended.
Mr. Wilson, have you consumed any medicine or alcohol recently?
No, ma'am, but this case is a 2020, ma'am.
Oh, understood. It's
Okay.
still within the last 10 years. So do you want to plead or would you like a trial?
No, I'm pleading. I just want to make that clear.
Oh, I clearly took a note of that. Thank you. Mr. Wilson, are you satisfied with your attorney?
Yes,
All right. And are you entering this plea freely, willingly, and knowingly?
yes, ma'am.
Is anyone forcing you to take this plea offer?
No, ma'am.
And has it been explained to you that if you decide to plead guilty to this charge, you will not have the opportunity to try this case in a court of law? You will not confront your accuser, challenge the evidence and the testimony brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct?
Oh, can I plead no low tenure? Because I'm guilty of failure to appear.
Well, a person can plead guilty, can ask to plead guilty or ask to plead nolo, but if you use nolo, the court would have to agree, and you can only do that once in every 5 years. So if you haven't done that in the last 5 years, you can ask the court to accept a nolo plea.
It's on record. I did.
Mr. Jones, any objection to a nolo contendere plea?
We would defer to the court's ruling, Your Honor.
I'll accept a nolo contendere plea, and this will be no contest to a disorderly conduct. Sentence is 12 months to serve 26 days, credit for time served 13 days, balance suspended. I appreciate your guilty plea to the bench warrant, but the state is going to be dismissing that charge, so that is not necessary. Mr. Jones, if you could submit the null pros to position 35 to Miss Melissa Grace, truly appreciate that.
Yes, Your Honor.
All right,
Thank you, Anna.
thank you.
I think it makes it possible. Say hi, Dennis Lynn.
Position 4, Davis.
Mr. Dotis, do you still need to speak to Mr. Davis?
Your Honor, I've spoken to Mr. Davis. At this point in time, we would waive arraignment and enter a plea of not guilty. He's currently held on an FTA related to this charge, and we would ask this court to set that aside. This case is from I believe 2018 or 2019. He has a good address. He didn't update his address before his new address. Moving forward, that won't be an issue, and he understands that even though the underlying protective order may no longer be in place, that this incident did occur before that, and that did not resolve the case, which is why he was not checking with the court. But moving forward, he is clear on his court dates. He is a veteran and does work at the VA Monday through Wednesday as part of the trauma program. And he's a veteran. He receives treatment at the VA Monday, Tuesday, and Wednesdays for trauma related to his service. It's a program called PRRC. He also volunteers on Thursdays. As stated, he does have a good address that is updated in Odyssey. It was updated a few days ago. And he's clear that he needs to check the mail and contact the court to make sure that there are no issues and lapses in the future.
Miss Tyson,
Yes, ma'am.
any matters since 2019?
His last arrest was out of East Point. Last arrest it was December 11th of 2019, aggravated stalking and criminal damage to property in the second degree. I believe that case is still open. No disposition is listed on the GCIC.
Could you give me the incident date again?
It is, let's see, December 11th of 2019.
I see a time served entry on that charge.
Okay, yeah, nothing is listed on GCIC for that one, but other than that, nothing after that in the FTA.
All right. I'm sorry, who is prosecuting in this matter? Ms. Bickerstaff or Ms. Yeah.
Yes, it's Ms. Bickerstaff.
All right. So Ms. Bickerstaff, this is a $10,000 bench warrant for a failure to appear in court to, I think it was a plain arraignment calendar back in 2018. For the aggravated stalking charge for that same TPO was demarked. So how is the state proceeding on this particular matter?
The state's recommendation is 12 months to serve.
Oh, okay. No, they're asking for the bench warrant to be set aside.
Right. This is for position 4, correct?
Position 4, yes. Christopher, Mr. Dodis is filing a waiver of arraignment and having the case set for trial.
Okay, we can set aside the bench warrant.
Okay. I'm going to set aside the bench warrant. We need to, Mr. Dodis, I presume you'll send me a proposed order?
Yes, Your Honor, I'll submit that as soon as I leave the courtroom.
Okay, and this case is going to go back to Judge Edline's division to be scheduled again for either a plea and arraignment or a trial. You filed a waiver of arraignment, so it's going to be scheduled for further notice for trial. And if you just give me a moment. I don't know if the TPO is still in place. I doubt it is, but pending trial in this matter, Mr. Davis, you are still to have no further contact with Lily Davis, Lillie. You have to stay 200 yards away from her. You're not to communicate with her in any way, form, or manner. Understood?
Understood, Your Honor.
You are also not to possess any weapons or any firearms and not to consume any illegal drugs.
Yes, Your Honor.
All right. Make sure your address, your contact information, phone number, email, everything are current with the court. If you make any changes, you're more than welcome to come to 160 Prior Street and update the clerk's office with your contact information.
Yes, Your Honor.
Otherwise, we'll have to issue another bench warrant for your arrest.
I understand, Your Honor.
All right. Thank you, sir.
Thank you.
Position 23. Ms. McLeod's client.
Can I ask you a second? We need to.
Ms. McLeod, have you interviewed all the clients for the cases you have on this calendar?
Your Honor, it's just 2.
It's just 2, okay.
Yes, it's Miss Gibbs, no, and Mr. Fitz, Your Honor. It's just that she has several.
Okay. Is that position 9 to 13?
10 through 13, Your Honor. Devin Fitz is my other client, and he's at position 9.
Okay, and then you have this one, position 23. Okay.
Is it 23? They must have changed it.
Latoya Moore? I'm sorry, ma'am.
No, that's not my client.
Miss, what's your name?
Katrika Gibbs is my client.
That's the one in front of you.
Oh, Miss Gibbs, okay. All right, folks, if the deputies inadvertently call out the wrong name, I hope one of you will chime in and say, no, that's not my name. It helps, okay.
Thank you, Your Honor.
Let me confirm. No problem, Deputy Milton. The lady seated at ACDC, is your name Katrika Gibbs?
Yes, ma'am.
All right. So if the deputies ever call out the wrong name, chime in. You can say, that's not my name, okay?
Okay.
All right. You don't want to take the fall for somebody else.
Yes,
right?
you're right.
Okay.
Yes, ma'am.
All right. Ms. Katrika Gibbs, your case number is 22 CR 3748Y. and your attorney is Ms. Maureen McLeod. You've been advised of your right to remain silent. Ms. Gibbs is accused of battery causing substantial physical harm from June 11th, 2022. And Ms. McLeod, how's your client proceeding?
The state has made a recommendation which my client does not accept, Your Honor.
Okay.
She also has 2 other outstanding cases and 2 FTAs, it appears. That's why the numbers look like so much on the calendar. My client would like to ask the court to consider giving her some kind of bond on the FTAs. She already has a bond on the other cases, Your Honor, because the state has offered 365 days to serve, and we do not think that's a reasonable offer.
Yeah, sure. So sorry. Yes, she has positions 9 through 13.
That is correct, Your Honor.
All right. So the second case is simple battery and 23 CR 1115J from July 4th, 2022. The third case is battery family violence from May 20th, 2023. And then her 2 bench warrants, 424 and 425.
That is correct, Your Honor.
Okay, all right. And are you planning to file a waiver of arraignment for positions 9 and 10?
Yes, Your Honor.
Well, 9, 10, and 11.
Yes, Your Honor. I'm going to file a waiver of arraignment for her 3 cases. She has been in jail, I think, since May 25.
Most likely. Okay. Ms. Bickerstaff?
Yes, Your Honor. The state's recommendation on all 3 charges for positions 9 through 11 is 12 months to serve to run concurrently with one another. And right now I'm trying to look up just quickly the 2 cases that the defendant FTA'd on. Which ones, which of them?
It's 9, 10, and 11.
The allegation is that she FTA'd on the simple battery and on the battery substantial harm.
Okay, so she FTA'd on positions 9 and 10.
That is correct. That's my understanding, Your Honor, based on I looked in Odyssey.
Because she was arrested on a separate offense for position 11.
That is correct, Your Honor.
Okay.
And I want to point out to the court that the FTA on the battery, the simple battery, it was actually a Zoom appearance. And my client tells me that for some reason, she just forgot on that day. It was not even an in-person.
Well, that is still a bench warrant matter.
I understand, Your Honor, but I spoke to my client and she said for some reason, she just forgot that she was supposed to log in.
And then a month later, she got arrested for battery domestic violence. And
yes, Your Honor.
Okay. I'm just waiting for Ms. Bickerstaff to give me her position on the defense's request to set aside the bench warrant.
The state objects to setting aside the bench warrant, Your Honor. As Ms. McLeod just stated that she forgot that she had a Zoom hearing, that's not an excuse not to show up for court.
I'm not saying it's an excuse. I'm just saying she was being honest about what happened.
Understood.
Understood. The state objects.
Ms. McLeod, this and what's the state's offer for the 3 cases that we have against her right now?
It's 12 months to serve.
Okay. And she's been in custody now for?
Since May 25, Your Honor.
Okay. And she's got a $5,000 good bond.
That is correct.
Battery family violence.
Yes, Your Honor.
And would she be able to make bond?
She won't be able to make bond, Your Honor. She doesn't have anybody to help her.
Okay, so even if I set aside the bench warrant, will she still be in jail?
She might be, Your Honor. She might still be in jail.
All right. I'm going to set aside the bench warrants, which is positions number 12 and 13. And all three cases are going to be further notice for trial, and they will be scheduled before Judge Edie.
Thank you, Your Honor.
All right, and well, she's got other problems. On the battery family violence, she's got a $5,000 good bond. Okay.
Yes, Your Honor. She does have that.
Okay. On position number 9, the $3,000 signature bond through pretrial is revoked. Due to her 2023 arrest for battery family violence. So that's going to be a $3,000 good bond right there.
So more than likely, she will still be in jail, Your Honor, because.
Yeah, I mean, I just need to make her understand this is the stock reality. On position number 10, which is the charge of simple battery.
I didn't understand.
Well, your attorney will explain, or
I will explain to you, Ms. Gibbs.
Oh.
Position number 10, I'm going to set a bond of $1,000. And that's going to be a signature bond through the jail. The bond had never been set in that case. This was just an accusation matter. Right. So, Ms. Gibbs.
Yes, ma'am.
You were arrested in June of 2022 for a battery causing substantial physical harm. At that time, you were given a signature bond through pretrial. Do you understand?
Yes, ma'am.
But because you were arrested in May of 2023 for another battery charge, that signature bond gets revoked and converted to a surety bond.
What's a surety bond, ma'am?
A bond that you have to pay for in order to be released.
Yes, ma'am.
Okay. Position number 10, in which you were charged with simple battery from July 4th, 2022. There was no bond set in that case, and I'm going to set a bond for $1,000 signature bond through the jail. That bond you won't have to pay. Do you understand?
Yes, ma'am.
But you have to still have no contact with Antisha Smith.
I don't know who she is.
I'm just telling you what the charge is. You were charged with simple battery against one Antisha Smith on July 4th of last year.
I've already spoken to my client and she says she absolutely does not know who that person is.
Okay, so well, discovery was filed on March 29th, 2023, Ms. McLeod. So I'm sure you'll be able to get that. And
No, I would have to ask for it to be resent to me, Your Honor, because it's not available to me in Odyssey.
okay,
I just started representing her.
Ms. Bickerstaff, would you be so kind? Looks like the documents were filed on March 29th.
Yeah, I'll send them to Ms. McLeod.
Thank you.
Thank you. And then on the third case, position 11, that bond's already set at $5,000 surety bond. So, Ms. Gibbs, the bench warrants, I've set those aside. Those are not holding you anymore, although I still don't condone the fact that you forgot about your court dates. When you have criminal cases pending against you, you cannot afford to forget those court dates. Do you understand?
Yes, ma'am. Yes,
You have 3 cases pending against you.
I wasn't aware of that, ma'am.
I can't help you there. Ms. McLeod, her bond is currently a $9,000 split.
Yes, Your Honor.
Okay. And I've set aside the bench warrants, and all 3 cases are going to be further notice to trial upon your filing of the waiver of arraignments.
I will have that filed today, Your Honor.
All right, appreciate it. Thank you. And the orders setting aside the bench warrants for position 12 and 13.
Yes, Your Honor.
All right. Did you have another case, Ms. McLeod?
I do, Your Honor, and I haven't spoken to my client yet.
And what's that name?
He is Mr. Fight. He's at number 9.
Okay. No, that wouldn't be number 9.
I'm sorry.
That's okay. If you just have the name.
I'm sorry, it's 8, number 8.
Number 8.
Five,
Devin
not
Alon? Devin Alon 5?
Yes, Your Honor.
Okay.
He's on 4 North.
He's at 4 North. Okay.
Yeah,
Perfect.
I have him right here.
All right. Thank you. Ms. Gibbs, thank you very much. We've concluded with your cases. All right. Devin 5. All right, Mr. 5, good morning. My name is Judge Law. We are addressing your case, which is position 8 on the calendar.
No, I'm not Miss Fife, I'm Miss Martin.
No. All right, thank you, sir. I'm addressing somebody else on the Zoom. All right, the individual seated at 4 North, are you Devin Elon 5?
Yes, ma'am.
All right, thank you. Mr. 5, you have a right to remain silent. Anything you choose to say about your case, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Maureen McLeod. Do you see Ms. McLeod on the screen? She's waving her hand in front of the screen. Okay. And your case number is 23 CR 3484Y for battery from May 29th, 2023. And Ms. McLeod, how are we proceeding with Mr. 5?
Your Honor, the state has made an offer. I have not yet had the opportunity to speak with my client about it.
Okay. And Ms. Grace, would you be able to put 4 North and Ms. McLeod in a breakout, please?
Yes, ma'am. It was Miss Champion.
All right. Please do. I'm just going to take a 30-second recess. I just need to answer this call from another judge. Thank you. Thirty seconds on the dot. Okay, great. All right, Ms. McLeod's in a breakout. And so we have courtroom 2 with Mr. Dotis. Mr. Dotis, who do you have?
This is going to be position 16, Mr. Hill.
All right. And then we will go to 3 South after that, then ACDC. I'm just going to be playing rotating chairs right now. Position, Mr. Hill. Okay. Mr. Dotis, your client is Todd Hill, case number 23 CR 3531G, charged with loitering or prowling and theft of lost or mislaid property from June 1st, 2023. Mr. Hill, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. And all right. Has there been an issue with the jail time?
Yes, Your Honor, maybe Ms. Bickerstaff can clarify. I think the spirit of the offer is no more jail time. But he does only have 15 days of credit. The offer gave him credit for 16 days, so he would be stuck in jail for another day. So we would just ask if it could be served 30 days credit for 15 days.
Yes, it's no problem with that, Mr. Dotis. It's my apologies for adding an extra day when I was going through numbers. But yes, the offer is meant to be a time served, 12 months to serve 30 days, credit for time served 15 days, balance probated to an anti-theft course, and to stay away from 620 Glen Iris Drive, as well as number 16, no further contact.
Oh, that's no contact?
Yes, no, it's not supposed to be no contact. I'm sorry.
Okay. All right. Mr. Dotis, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do so stipulate to the three elements for the purpose of this plea and would ask the court to accept the negotiated offer. My client will be residentially challenged, so we would ask if Your Honor would waive a few months of his probation to help him get on his feet, as well as switch him over to non-reporting status upon completion of the anti-theft course. I've given my client resources, including a recommendation for a theft class, so I'm adamant that he will complete that quickly.
All right. Any objection to non-reporting, Ms. Bickerstaff?
No objections, Your Honor.
All right. I will waive probation fees for June and July. And if he gets his anti-theft class done before the end of July, his probation will be non-reporting, so he won't be expending additional funds for probation fees, which will resume from August 1st onwards.
Thank you, Your Honor.
Okay. Mr. Hill, do you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Okay.
All right. Ms. McLeod, are you concluded your breakout or were you?
Yes, Your Honor.
Okay, I'll be right with you then. Thank you.
Thank you.
Mr. Hill, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am. Very.
Is anyone forcing you to take a plea offer today?
No, ma'am.
And has your attorney gone over the waiver of rights set forth in your plea documents, including your right to give up, including your you giving up your right to a trial, to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to one count of loitering and prowling and one count of theft of lost or mislaid property?
Guilty.
Your sentence is 12 months. Just, I didn't write it down. I'm so sorry. How many days was it? Was it 30 days?
Yes, Your Honor. Serve 30 days, credit for 15 days.
12 months to serve 30 days, credit for time served 15 days. The remainder of the time will be on probation. If you have no other cases holding you at the jail, you will have to report, you will be released within 24 hours and you'll report to probation within 7 days of being released. The probation office is located at 132 Mitchell Street in downtown Atlanta, and they're open on Tuesday, Wednesday, and Thursdays. You need to report to probation on any of those days. And once you're on probation, you need to make sure that you complete the anti-theft class. I will waive your probation fees for June and July. So it will be best if you get it done by the end of July, because you'll need to start paying probation fees from August 1st onwards. If you're done with the class by the end of July, then your probation will be non-reporting, and your attorney will explain that to you. At all times, you are to stay away from 620 Glen Iris Drive. Do you recall that location?
Yes, ma'am.
If you return to that location, you will be arrested again, and we get to do all this all over again. Wouldn't that be fun?
No.
Okay, thank you.
Thank you. All right.
All right, Ms. McLeod, you had position number 8 for a gentleman, I believe, at 4 North.
Yes, Your Honor, Mr. 5.
All right, now Mr. 4 North may be on a separate screen. Let me just check. All right. Okay. That was position number 8. I'm so sorry. I'm going through these pages. Okay. All right. And what was the outcome from the discussion?
My client would like to accept the state's offer. It's essentially a time served offer, Your Honor.
All right. And Ms. Bickerstaff, what was the offer again, please?
Yes, the state's offer is 12 months to serve 365 days, credit for time served 19 days.
I thought it said 390 days on the paperwork.
That's a big gap. So
that's what I saw, and that's what I told my client.
I don't know what paperwork y'all are looking at. So the Ms. Bickerstaff, would you like to review the document you sent to Ms. McLeod?
Yes, Mr. Walker would have sent the one that I'm looking at right now, and the offer is for 319 days.
Okay. Well, that's
which is still essentially a time served offer.
Okay, I'm sorry. I heard you say 19 days.
19.
Yes, 19.
I see on my paperwork 319, which is different from 19.
Okay, I'm just going to reiterate what Ms. Bickerstaff stated. Ms. Bickerstaff, you said 12 months to serve 365 days, 365. Credit for time served 19 days, 19.
319, 319.
Okay, I'm so sorry. We all heard 19, so
Yeah.
now that it's clarified,
was the
we are all on the
confusion.
same page. Excellent.
Yes,
Okay.
we are, Your Honor.
Okay, so it's and Miss and then the balance suspended.
Yes, balance suspended.
Okay, thank you. I'm sorry, Ms. Bickerstaff, you have about 2 decades ahead of me, so I'm my ears may be going right now. So
I heard 19 as well, Your Honor. So that-
oh well, that cakes, Ms. McLeod.
and I'm also old. I am
Thank you.
older than you, Judge.
So did I, Judge. So did
You
I.
heard everyone? I was just called old. Okay. All right. Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
All right. And Mr. Fife, please raise your right hand. Do you solemnly swear that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Mr. Fife, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings that basically, if you decide to plead guilty, that this will close your case out and that you won't have any further obligations in this case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
Please understand that by pleading guilty to this charge, you would be giving up your right to have a trial in front of a judge or a jury, to be able to confront your accuser, challenge the testimony and evidence brought against you, and have the state try to prove the charge against you.
Yes, ma'am.
How do you plead to 1 count of battery?
Yes.
Your sentence is 12 months to serve 365 days. Credit for time served 319 days. Balance suspended. This case is now closed. And if Ms. McLeod, does he have any other matters holding him there?
He does, Your Honor.
All right. So Mr. Fife, as far as this case is concerned, is closed. Thank you.
Thank you, Your Honor.
All right.
That does conclude my business before the court today. May I be excused?
Yes, thank you. Enjoy your weekend. Take care. Bye-bye.
Thank you, Judge. You too.
Position 32 and 33.
Is that 4 North?
Yes.
All right. Officer, I'll be right with you. I am going to, I think I said 3 South. And then I'm going to courtroom 2 and then ACDC and back with 4 North. So somebody please keep me in line on that one. Okay, Miss Grace? So 3 South, who do we have?
Position number 30, Walter.
Okay, 30. Mr. LaRon Walker is accused of failure to obey a stop sign, hit and run, and driving while license suspended or revoked from December 2022 in case 23 CR 3160C. His attorney is Michael McLean, who is present in courtroom 2. Mr. Walker, do you see your client? Do you see your? I'm sorry, Mr. Walker, do you see your attorney in courtroom 2?
Yes. Yes.
Okay, that's good. All right, and Mr. McLean, this is going to be a negotiated plea. Do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Jones, what's the plea offer?
Yes, Your Honor. The state's plea offer is going to be 12 months to serve, 180 days, credit for time served 30 days, balance probated with a defensive driving course, 80 hours of community service, and a $1,000 fine.
All right, I don't want to go over this again, but that was credit 30, correct?
30, Your Honor.
Okay, thank you. Mr. McLean, are those the terms to which your client has accepted?
It is, Your Honor, and this was reset from before for me to consult with, or for him to consult with another attorney. And before I say anything else, let me remind myself, Mr. Walker, did I mention to you that when there's a fine as part of recommendation, At the rate of $10 an hour, if you were financially challenged, you could request that it be turned into additional community service. Did we go over that?
Yeah.
Okay, and did you want to make it fine and community service as stated by the state, or did you want to convert anything?
Fine community service.
So I do believe I recall a conversation from a couple weeks ago, Your Honor, and just touched base with him yesterday. So if the additional fine could be converted at the rate of $10 an hour into additional community service, he would ask the court to do that because he's got another case. He doesn't have money, and it would just make sense if he's able to get out anytime soon. That would be best.
So basically, the defense is asking that after he's released, he'll be on probation. He will do a defensive driving class, and he will do a total of 120 hours of community service.
Correct, Your Honor. And if we did discuss the defensive driving class, he knows he has to find that on his own, that they're generally available. They cost a few $100s, and he will get them.
Well, the defensive driving's cost less than $100. As far as I know, the AARP program is less than $40. But the stipulation will be no driving unless he has a valid license, adequate insurance, and proper registration. So, Mr. Walker, is that your understanding of what you are seeking?
Yes.
All right. Mr. Jones, do you have any objection to amending the fine to additional, well, that will be an additional 100 hours of community service, not 40. I'm so sorry.
Yes, Your Honor. Part of our plea was for the $1,000 fine due to the fact that the defendant did hit and run and refused to return to the scene of an accident. He did cause damage to the vehicle. So therefore, our stance will stay at the $1,000 fine.
Oh, so you're not willing to amend it to an additional 100 hours of?
No, Your Honor.
Okay, thank you.
I always think of conversion in that sense as just being at the court's discretion because it has to do with financial circumstances of the defendant.
You would be correct, but in the meantime, I have someone on iPhone on this Zoom who wants to be heard on this case. So whoever is iPhone, you need to start your video and unmute. All right, this is my last call. I'm looking at the chat feature. Someone on iPhone has asked to speak on the Walker's case.
Yes, ma'am. I am the gentleman that Mr. Walker hit on December 17th.
Officer, okay, I'm so sorry. You're walking around and I can only see your body cam.
Okay. I am the personnel that Mr. Walker hit on December 17th.
All right, so, okay, can you lower the device so we can see you?
Yes, ma'am.
Perfect. Don't move it. Oh, raise it a little bit. Perfect, perfect. All right, officer, may I have your name, please?
Yes, Investigator Fitton, Fulton County Sheriff Office. I'm downtown in court. December 17th,
yes, sir.
Mr. Walker ran the stop sign at South River Industrial and Forest Park Road. Mr. Walker did have a firearm on him at the time as well. When he found out, when I identified myself who I was, he hurried up and left. He did have probation violations on him at the time.
Mm-hmm.
So I did want to bring that to the court's attention.
All right. And so I do understand that he is currently in custody.
Yes, he is.
All right. And this was from as you said, he's already got those, these 3 matters that were from December 17th, 2022. And
Yes, ma'am.
he has been booked in on some serious felony charges from April
Yes, ma'am.
30th, 2023. So
Yes, ma'am.
Investigator Patton, even if I accept the plea at the present time, there is currently no indication that he will be released in the near future. Is that your understanding? Investigator?
Yes, ma'am, I do.
I was just wanting to make sure that you understand that even if I accept the plea offer today, that there is no indication that he will be released in the very near future.
Yes, ma'am.
All right. Anything else, Investigator Patton?
No, ma'am.
All right, thank you. Okay, Mr. Jones, okay, I think Mr. Jones has already spoken. So, Mr. McLean, you've indicated that the court has the discretion to decide to amend his $1,000 fine to community service, correct?
Yes, sure. I'm just simply saying I never think of that particular issue as being one that is part of breaking a negotiation. Thank you.
Under these present circumstances, I am actually going to go with the state's recommendation and keep it at $1,000 fine. He will be on probation every month. Once he's released, that's when the probation will, if I accept the plea, that's when the probation will kick in. He will be on probation every month for the 12 months. For at least the remainder of the this is 180 days, so this would be for 6 months. So he will be on probation for 6 months to complete the 80 hours of community service, to pay off the $1,000 fine, and to do the defensive driving. So, Mr. McLean, would your client still like to proceed?
Yes, Your Honor. He understands that the future is not known yet, so he would like to proceed with this, Your Honor.
Okay. And as you've already indicated that you stipulate to the factual basis, venue, and ID.
We do.
All right, thank you. Mr. Walker, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Walker, have you consumed any medicine or alcohol recently?
No.
And have you understood everything that we've been discussing so far on Zoom? You need to speak up louder.
Yes.
And have you understood the statements made by your attorney and by the prosecutor?
Yes.
Are you still willing to enter a plea freely, willingly, and knowingly?
Yes.
And you understand that by entering such a plea, that you will be on probation once you are released from the Fulton County Jail or from any other facility?
Yes.
And you also understand that if I accept your plea, that you have to give up your right to go back to court to challenge these charges in a court of law in front of a judge or a jury, to be able to have the assistance of counsel to challenge the evidence brought against you, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to do that?
Yes.
How do you plead to failure to obey a stop sign, hit and run, and driving while license suspended or revoked?
Yes.
Your sentence is going to be concurrent, is 12 months to serve 180 days, credit for time served 30 days. You will have additional time to serve for this particular case. The remainder of the time will be on probation, which will start as soon as I've indicated that you are released from any detention facility. While on probation, you will complete a defensive driving program, 80 hours of voluntary community service, and pay a $1,000 fine plus any court costs or surcharges. That concludes your hearing. Thank you.
Judge Law.
Yes, Ms. Grace?
Can you tell me what charge the fine and community service are beyond?
And it will be concurrent for the driving, hit and run, and the failure to obey a stop sign. The community service will also be applied to all 3 charges. is a concurrent sentence for all three.
Thank you.
All right. I can't recall, but I think I promised, was it 4 North next?
Yes, 4 North.
Okay. And who do we have at 4 North?
Position 32 and 33. Williams.
No, 32.
This is Taekwon Jaden William Francois, arrested for 2 particular cases. The first one, position 32, is a charge of loitering or prowling and criminal trespass from April 19, 2023, 23 CR 003563F. The second case is from an incident from April 13th, 2023, case number 23 CR 3564F, charge is loitering or prowling. And your Mr. William Francois, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean.
Your Honor, as
Mr.
indicated, Your Honor, if I might interject, I'm sorry. As indicated on the announcements, when I was in the jail building yesterday, during different parts of the time period that I was in the building, they did not bring out Mr. Williams Francois to the visitation booth. I have not spoken to him yet. So
okay,
because there are a certain number of extra days involved in the state's offer, and because there are other legal matters going on, this case could be safely without harm, I believe I'm correct, that we could reset this to another day to afford me the opportunity to talk to him in a situation that's not just a breakout room.
Okay, I can reset him to either June 22nd or June 29th.
What do you think, Mr. Williams? Do you think that that would be all right, the 22nd or the 29th?
All right, we'll reset him to June 22nd.
I'll see you in jail before then in a visitation booth, Mr. Williams.
All right, the next one was ACDC. Who do we have?
Ms. Martin, position 22.
That's a negotiated plea, Your Honor.
All right. This is State versus Barbara Martin, case number 17 CR 2220G. Ms. Martin was accused of simple assault from December 5th, 2015. Ms. Martin, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Do you see Mr. McLean on the screen? Okay, I think we have to unmute her, Deputy Milton. Deputy Milton, please unmute ACDC. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right, Mr. Jones, what's the plea offer?
Yes, Your Honor. So this is going to be a time served plea, 12 months to serve 28 days, credit for time served 14 days, balance suspended. Yes, Your Honor.
Thank you. Ms. Martin, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Martin, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea offer today?
No, ma'am.
Please understand, I do know the case is from 2015, but even if you decide to plead guilty today, you would have to give up your opportunity and your right to challenge this charge in a court of law. You will not have the right to have the assistance of counsel to confront your accuser, challenge the evidence and the testimony brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple assault?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended, which means this case is now closed. If you have no other cases holding you at the jail, you should be released within 14 days. Thank you.
Next, we have position 23, Ms. Moore.
All right. I will be with Miss Moore in as soon as I do position in courtroom 2. Debbie Milton, don't leave. I'll be right with Miss Moore. Courtroom 2, who do we have?
This is positions 5 and 6, Michael Davis.
All right, that will be Mr. Dotis' case.
Yeah. Okay. That's makes sense to me, yeah.
What's the name, so I can put it in the chat?
All right, Mr. Michael Davis is positions 5 and 6. Position 5 is case 23 CR 3514Y, in which Mr. Davis is accused of battery, family violence, and willful obstruction of an officer from February 1st, 2023. Position 6 is 23 CR 3516Y, in which Mr. Davis is accused of giving false information to an officer, 2 counts of obstruction of an officer and loitering or prowling from May 22nd, 2023. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Angelo Dotis. And with regard to both these cases, Mr. Dotis, what's the announcement?
Yes, Your Honor. After speaking with Ms. Bickerstaff, I did let her know that we are going to request a 2-week reset to readdress this on, if possible, on June 29th SAP calendar. I had a social worker speak with Mr. Davis, and we're going to try to find him an inpatient program within the next 2 weeks.
All right, 5 and 6 are reset to June 29th at 9 a.m. Thank you.
Thank you, Your Honor.
All right. ACDC, Ms. Moore.
Come on, Brown.
Ms. Brown.
Right here, the first one.
Could you tell me your name again, please? The young lady at ACDC?
Latoya Moore.
Moore, okay, I had the right name. Ms. Moore is position 23 and is accused of battery, domestic violence from a November 2022 incident in accusation number 23 CR 1559D. Ms. Moore, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And Mr. McLean, we are going to do a negotiated, am I correct?
Arraignment.
Oh, this is an arraignment, okay.
Not guilty. Bond is new. She's already made her bond. This is not holding her in court, in jail.
Okay,
It's just not guilty.
do you waive a reading of the accusation?
We do so waive that reading. Yes, Your Honor.
Thank you. Ms. Moore, you've been accused of a misdemeanor offense, which is battery, domestic violence allegedly occurring in Fulton County, Georgia on November 2nd, 2022. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. Once the case goes to trial, and if the prosecutor carries his burden of proof and you are convicted of such an offense, you could be facing a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Could you repeat that, please?
Not guilty.
All right. Your case has been arraigned and is going to be further notice for trial. Thank you. Court, I'm sorry, 4 North, who do we have? 4 North?
Yes, Your Honor. Position 24, Mr. Owens.
Mr. Owens is going to be on a different calendar today, Your Honor.
Is that
the 11 a.m. calendar?
Competency calendar.
Duffy, you'll check your chat. It's about Keith Owens.
All right.
Thanks.
So we won't need him on this calendar now.
Okay.
All right. Thank you. We typically it's up to you. We will have Mr. Owens available at 11 a.m. if he needs to be present in the breakout competency calendar. Okay? All right, courtroom 2, who do we, oh, just 1 second. 4 North, do we have anyone else?
Yes, I have actually 3 more. 25 and 26. Is that
25 and 26 is John Pearson. Mr. McLean?
Similar announcement to that of Mr. Taquan Williams Francois, in that he was not available to be interviewed yesterday, and the state's offer is considerably an amount of extra days. So we could reset him to the same day, and I could more leisurely, although leisurely is not really a descriptive term, I could more thoroughly talk with him.
All right, Officer, Mr. Pearson's case is going to be reset to June 22nd, 2023 at 9 a.m. His attorney, Mr. Michael McLean, will visit him at the jail before then to discuss the case with him.
this is just a warrant for FCA. I don't have no location, nothing.
Mr. Pearson, if you will see the screen, Mr. McLean, can you please wave your hand at him? All right.
I'll be glad to speak with him briefly today and see if this is okay with him. And if it's not, and if he wants to go forward, we certainly can. We could do a breakout room.
Okay, Mr. Dotis, do you have anyone else that you're representing? Just 1 second, Mr. Pearson. Mr. Dotis, do you have anyone else you're representing in courtroom 2?
Yes, Your Honor. The remaining clients are my clients. We have 2 of them. We should be able to go through.
Okay. Will the host please place 4 North and Angelo, PD Angelo Dotis laptop in a breakout, please? Mr. Dotis, who is your next case?
Your Honor, this is position 1, Mr. Brandon Brown. This is also going to be a reset request for 2 weeks to the June 29th SAP calendar. I let Ms. Bickerstaff know that as well, as we have our social worker working on this case.
How far out am I resetting the case?
2 weeks, Your Honor, June 29th.
Okay. Reset June 29th for Brandon Brown. Thank you.
Thank you, Your Honor. You ready?
Position 2, do you have Antonio Carter?
Yes, Your Honor, he's walking up now.
Okay. And Ms. Bickerstaff, is restitution still an issue for Mr. Carter?
No, Your Honor, I explained to PD Dotis that we weren't able to contact the victim, so we're not gonna ask for restitution.
Okay, so this will be a negotiated plea?
Yes, Your Honor.
This is State versus Antonio Carter, position 2, case number 23 CR 3491E. Mr. Dotis is charged with theft by receiving stolen property, possession and use of a drug-related object, and giving false information to an officer from May 31st of this year. Mr. Carter, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Please raise your right hand. Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Repeat your answer.
Yes, ma'am.
All right, thank you. Mr. Dotis, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do so stipulate to the 3 elements for the purpose of this plea. We would request, if there's no objection, to non-reporting status upon completion of the theft course and the 40 hours of community service, as well as if this court could waive a few months of Mr. Carter's probation. He is residentially challenged, and we'll try to obtain a job, and I have provided him with resources and probation's contact information, so I believe he will be successful. Just ask for a helping hand.
Ms. Bickerstaff, what's the plea offer?
The offer is 12 months to serve 32 days, credit for time served 16 days, balance probated to an anti-theft course, 40 hours of community service, to stay away from 215 Forsyth Street, and no further contact with Daviet McNair. Daviet is D-A-V-E-A-T.
And what is this establishment at 215 Forsyth Street?
It's near the Greyhound bus station.
So not at the Greyhound bus station?
No, it's near it. That's where officers arrested the defendant.
So if I require him to stay 200 yards, he won't be able to even enter the Greyhound bus station.
Yes, well, we can take the stay away off. We can do without the stay away order.
All right, but no contact with Deviat McNair.
Yes, that's correct.
All right. And any objection to non-reporting?
No objection.
All right. And Mr. Carter, excuse me, for Mr. Carter, I'll waive his probation fees for June, July, and August. And he will need to make sure he's completed the anti-theft class and the 40 hours community service before the end of August. Otherwise, he'll still be reporting and paying probation fees from September 1st onwards.
Understood, Your Honor. Thank you.
All right. Mr. Carter, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
I can see you are speaking, but I can't hear you.
Yes.
So,
Yes.
okay. Mr. Carter, is anyone forcing you to take this plea offer today?
Come on.
And do you understand that if you decide to plead guilty to these charges, that you would have to give up your right to go back to court and have a trial in front of a judge or a jury, to have the assistance of your attorney to help you challenge the evidence brought against you, the testimony that you will hear in court, and to have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
How do you plead to one count of theft by receiving stolen property, possession and use of a drug-related object, and willful obstruction of giving false information to an officer?
Yes.
Your sentence is going to be concurrent and applied to all three charges. Is 12 months to serve 32 days, credit for time served 16 days. The remainder of the time you will be on probation. If you have no other cases holding you at the jail, you'll be released within 24 hours, and you must report to probation within the next 7 days, next week at 132 Mitchell Street. While on probation, you will complete an anti-theft class and complete 40 hours of voluntary community service. I recommend that you complete everything before the end of August 2023, because if not, you will continue reporting to probation and start paying probation fees from September 1st of this year. Your probation may be non-reporting as long as you complete the anti-theft class and the community service.
Right.
Thank you. Okay. Next position, your next case, Mr. Dovitz, is okay, position 14, Hairston.
Yeah, Your Honor, position 14, I was informed that he was transferred to medical, so we're going to request a 1-week reset.
Okay, reset to June 22nd. This is a medical reset. 15, Michael Herbert.
Your Honor, I was unable to speak with Mr. Herbert yesterday, so I will need, as soon as he appears, I will need to either speak with him on the phone or do a breakout room when Attorney McLean is back.
He's not present?
Position 15, he might be with the jail staff. I'm not sure what floor he's
Okay.
on. I was
So
unable. So we're just holding on him.
Okay, still holding on 15 then. What about 17 and 18, Ivaskid?
Yes, Your Honor. Position 17 through 19, I was informed were a loan out. I'm not sure where that loan out was to at this time. We'd also request a 1-week reset.
Right, reset to June 22nd.
And Your Honor, position 7 was also a loan to Grady, so we would request a 1-week reset for position 7.
June 22nd. Ooh, Judge Williams is not going to be happy with me. Okay. All right. And I think that was it, right?
That's it for my half of the calendar. Maybe it for Attorney McLean. I'll let him address when he returns.
Okay, is he done with his breakout?
He has not returned to the room yet, so I don't believe so.
Okay, Miss Kawayan Owens, I will address your question as soon as Attorney McLean is available. Okay, I'm just going to go over the calendar while we're waiting for Mr. McLean to resume with the calendar. Position 1 is reset to June 29. Position 2 was a plea. 3 was a plea. Position 4, Mr. Dotis, you're filing a waiver of arraignment and it's further notice for trial, and the bench warrant is set aside. Position 5 and 6 are reset to June 29. Position 7 is a Grady reset to June 22nd. Position 8 was a plea. Position 9, Gibbs is a waiver of arraignment. 9, 10, and 11 are all waiver of arraignments. Position 9, her signature bond is revoked and a $3,000 good bond is instituted. Position 10 is a $1,000 signature bond through the jail. Miss Grace, I will send you an order for those 2 cases. Position 11 has already got a $5,000 surety bond in place. Position 12 and 13, the bench warrants are set aside. And I believe Ms. McLeod is going to send you an order to set aside position 12 and 13. Position 14 is a medical reset to June 22nd. Position 15, same announcement, reset to June. No, we are holding on position 15, excuse me. Position 16 is a plea. Position 17, 18, and 19 is a loan out, so it's reset to June 22nd. Position 20 is arraigned and further notice for trial. Position 21, we are holding. Position 22 was a plea. Position 23 is arraigned and further notice for trial. Position 24, we are holding. I think Mr. McLean was talking to Mr. Owens.
And Your Honor, I believe Mr. Owens should be on today's competency calendar. That was
on the competency calendar. That's correct.
I'm sorry, what was position number 21?
21, we are waiting for an announcement from Mr. McLean.
Okay.
25, 26 are reset June 22nd. 27 and 28 were pleas. 29, Spells was a plea. 30, Walker was a plea. 31 was a plea. 32 is reset to June 22nd. Same announcement for 33, reset June 22nd. 34, Wilson was a plea. 35, Wilson is null prost. Okay, Mr. Dotis, could you please advise Mr. McLean that we are ready to address his cases?
Yes, Your Honor. I will go reach him. In the interim, I would note that we do have a bench warrant calendar if we want to sound for any of them.
Yeah, I'm going to do that. Okay, I'm going to address my domestic violence bench warrant calendar. This is a calendar that's actually scheduled for 11 a.m. It's about 10:52 a.m. at the present time. I'm going to just sound out to see who's present, and then we can address the bench warrants. Robert Lee Bonner. Robert Lee Bonner, if you're present. Okay, Mr.
Here.
Bonner is present.
I'm here.
All right, that's good. William Thomas Harris. Mr. Bonner, please keep your video on.
Okay, I didn't know.
Keep your video on, but keep your audio on mute. Mr. William Thomas Harris. I don't see William Thomas Harris. And Tariq Amir Rains. Tariq Amir Rains. All right, I don't see Mr. Rains. Who do we have at 4 North?
Channel. This is Mr. Pearson.
All right, that was Mr. McLean's client. Mr. McLean, is he back with us?
I will go find it, Your Honor.
All right.
We was in the breakout room and we got disconnected somehow. So we was trying to, I guess, get back in the breakout room.
Okay, I see. Will the host please place 4 North back in the breakout room as long as Mr. Dodis's laptop is also in the breakout, please? Thank you. Francois, please tell Mr. Dodis that McLean is still in a breakout.
Oh, Dodis stepped out, Judge Law.
Okay. Mr. Dodis, yeah, Mr. McLean is still in a breakout with Mr. Pearson.
Right.
Okay, let's address the DB bench warrant matter. Position number 1. This case is 21 CR 005793F. This is State versus Robert Lee Bonner, BONNER, who's present via Zoom. Mr. Bonner has filed a motion to set aside the bench warrant in this particular case. Mr. Bonner was accused of battery, domestic violence from an incident of November 13, 2020. And if you just give me a moment. Mr. Bonner, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And Mr. Dodis, are you representing Mr. Bonner today?
Yes, Your Honor.
Okay. It appears that Mr. Bonner failed to appear in court for a plea and arraignment matter on April 25th, 2023, and a bench warrant was issued on April 28th, 2023. All right, that's pretty much it. Mr. Dodis, do you have a comment?
Yes, Your Honor. I did reach out to Mr. Bonner Tuesday, and as a side note, he does qualify for the services of the Public Defender's Office. Mr. Bonner did not intentionally miss court. An old address was in the system. He has since updated his address. He updated it on June 5th as soon as he learned of his failure to appear. That address, I did verify it with him. It is the address on the reset notification, and it is the current address in Odyssey. Mr. Bonner had matters in a separate county, and while that wasn't why he missed his court date, he did think that he updated his address at all of the appropriate locations. He's now clear that that wasn't the case, and I provided him with information to make sure that if there are any changes in address or contact information, he knows to contact the state court office. Additionally, he knows to not only keep an eye out on his mail, but to check in every couple of weeks to make sure that he's aware of any further court dates. So we would just ask this court to set this aside.
When was he released from Clayton County?
Your Honor, it was before this court date. I did not have time to verify it and obtain a proof of incarceration, but it's not the reason that he missed the court date.
Do you mind if Mr. Bonner responds?
If Mr. Bonner wants to respond to that one question, that's.
Mr. Bonner, you have to unmute. When were you released from Clayton County?
Yes, yes, ma'am. Can you hear me?
Yes.
Okay. I was released from Clayton County on February the 22nd, but I wasn't released. I was transferred to another facility, which is Jasper County, and I was released from Jasper County February the 28th.
Okay, thank you. You may mute your screen. Ms. Bickerstaff, do you have any objection to setting aside the bench warrant?
Yes, the state's position is not to set aside the bench warrant for missing the plea and arraignment on April 25th, 2023. I'm seeing the address that was in Odyssey that it was sent to was 138 Oak Drive, and it was the defendant's responsibility to update his address prior to, if he changed to, I'm seeing in Odyssey Was it 2980
Sorry, we would-
Jonesboro Road? Is that the correct address now?
Hang on, I'm sorry. Yes, Mr. Dotis, what was that?
We would object to the address being read on Zoom where this is being live streamed on YouTube. If we want to mention addresses in the chat, that's fine. But I think we all have access to it without saying.
This information is public record. It's not, unless there was something extraordinarily difficult, objection overruled. Okay, so I think Mr. Dotis did indicate that the notice was sent to his old address and that he updated it after the bench warrant was issued. I think that has been stipulated. So anything else, Ms. Bickerstaff?
No, that's all from the state.
All right, I'm going to grant the motion to set aside the bench warrant. Mr. Dotis, if you could please submit the proposed order to Miss Melissa Grace. And his bond order still remains in place, so which means that he is required to have no contact with Michaela Fraser and to stay away from 960 Constitution Road, no illegal drugs, weapons, and alcohol. And presently, Mr. Dotis, I don't know if you've had a chance to discuss with him. Is he planning to be arraigned today, or are you filing a waiver of arraignment?
I can file, I've discussed his case and I will file a waiver of arraignment if he has not yet been arraigned on this case.
All right. So, Mr. Bonner, your attorney is the Public Defender's Office, and they will be filing a not guilty plea on your behalf. Is that your understanding?
Yes, ma'am.
All right. If you change your address or contact information, you need to make sure you let the court know so that we can send out the notices to the correct address. Otherwise, we go through this all over again. At this present time, I'm going to set aside the bench warrant, so there are no outstanding bench warrants, at least for this case, in against you. Understood?
Yes, ma'am. So I'm clear to like move around, because I've been in the house for like the last 2 weeks and I have a job, and my job has been holding for me because I told them the situation, and I didn't want to like be moving around because I didn't want to like get arrested or nothing like that. So after today, so that is like a time frame I should wait or anything like that.
Maybe wait till 3 o'clock today. As soon as Mr. Dotis sends me the order and I sign it and we file it. But if you've been there and if you've been under, well, self-imposed house arrest, then you can step out after 5 o'clock today. Would that be
Okay.
comfortable enough to you?
Yes, ma'am.
All right. As I indicated, your case is your attorney has filed a not guilty plea, so your case is going to be scheduled for trial. Presently, your case is assigned to Judge Richardson, so please be sure that you keep your address and check your mail for the next court date before Judge Richardson.
Okay, thank you.
All right. Well, I'm still waiting on Mr. McLean. It is 11:01, so let's see if our other two cases have appeared. William Thomas Harris on the bench warrant calendar. William Thomas Harris. This will be a good time for Mr. Harris to appear. Mr. Walker, you're free to go. You're free to go.
Okay, thank you. Okay.
And Your Honor, if I don't have a phone in the room, but I did speak with Mr. Harris, and I'm not sure why he's not on the Zoom, but I would ask to hold so that when I have my laptop back, when Attorney McLean comes back, I can call to verify that Mr. Harris doesn't work.
Okay, I will address that case after, well, maybe even after the competency matter. So please remind me, okay?
Thank you, Your Honor.
All right. The next one is Tariq Amir Rains, R-A-I-N-E-S. I see someone on Zoom called Rick, R-I-Q. Are you Tariq Rains?
Hello, Your Honor. How you doing today?
Doing good, thank you. All right, Mr. Rains is position 3 on the bench warrant calendar, 22 CR 2403C, in which he was accused of simple battery, domestic violence, and 2 counts of reckless conduct from a April 2022 incident. Mr. Rains, yeah?
My apologies. This is Attorney McLean's client. I'd be happy to address, but I do need my laptop back to look into Mr. Reeks.
Understood. Okay. Well, in that case, Mr. Rains, you are represented by Public Defense Counsel Michael McLean. Is that your understanding?
No,
So you've
they
not.
said I
spoken-
didn't. They said I didn't qualify for a public defender.
Oh, okay.
So I mean, if he's the public defender, I wouldn't mind, but I can speak for myself at this point. I mean, it's pretty simple to me, Your Honor.
Well, Mr. Rains, listen very carefully then. You have a right to remain silent about the facts of the case. Anything you choose to say, your statements will not only be recorded, but used against you in the treatment of your case. You have a right to an attorney. If you cannot afford counsel and you financially qualify for the services of the Public Defender's Office, then,
Yes,
then we can appoint counsel to represent you. Otherwise, you have a right to hire your own private attorney, or you can waive your right to counsel, understanding that you are responsible for any legal decision that you make and how it impacts your particular position, especially in terms of any other open cases, your job, your ability to maintain your freedom, your residency if applicable.
Yes,
So,
ma'am.
right now, I don't know if Mr. Michael McLean is representing you or not. If
Right.
Your Honor, and if I would like to confirm.
I haven't heard anything from a Michael McLean. That's why I can't attest to saying that I know for a fact that he's my attorney. I can't say that.
Your Honor,
I haven't received the email or anything. The last person I heard from the public defender's office was Mr. Charles Ford.
Mr. Dotis, what were you trying to say?
My apologies, Your Honor. I did want to have the opportunity to speak with Mr. McLean to see if in fact this gentleman qualifies or not before we proceed. If he wants to go forward on his own, that's his right to do so, but we do want to make sure that we are available if necessary.
All right, Mr. Rains, would you like to see if the Public Defender's Office was going to represent you, or would you like to proceed with that counsel? The decision is completely up to you.
Judge Law, only information I would like to know if I do let them be counsel, is there anything we could do today? Because it's not a hard case to me. I feel like we could get this over with today or get something moving, because it's like it's dragging out too long. That's why I'd rather represent myself, because it's like they want to throw me to counsel. Then when I go to counsel, they giving me FTAs about court dates that I keep showing up for, and the Zoom meetings are not happening. So this is the first Zoom meeting I had with you, and I remember when I came to you on first appearance. So that's why I'm like, if we can get something done today, yes, I would like counsel. But if not, respectfully, I would like to be represented by myself, because I can't rely on anyone else but myself at this point. I schedule my own court dates and everything.
You schedule your own court dates?
Yes, ma'am. I have
Really?
done my.
You
yes,
schedule
ma'am.
your own court dates?
Yes, I went to the clerk's office and had to go reschedule all of these court dates on my own. I've been doing this. No one has been doing this but me. So it's like, what is counsel gonna do for me at this point? I might as well do it on my own. And another thing I don't understand is, why is this a DV case when she does not live at their address? It's like they're putting in the wrong filing.
Before we continue, we'd like a moment to speak with you in private to address these concerns and see how you want to proceed. But I do want to remind you that everything right now that we're talking about is being recorded, so I do want the opportunity to address your concerns privately.
All right, Mr. McLean, I'm glad you showed up, because Mr. Rains has demonstrated a remarkable lack of knowledge with regards to the law and criminal procedure and court procedure. So, I mean, it's up to him whether he wants to proceed in this foolhardy process of representing himself, because I think he's digging his grave a lot deeper at the present time. So if you would like to have a breakout with him, what is your phone number, Mr. Rains, so that Mr. McLean may speak with you?
Okay.
470-534-8610.
8610.
I got it.
Your Honor, both of our phones are being used for first appearance interviews.
I can go to the car. Your Honor, with just a couple of extra minutes, I can run out of the jail, use my cell phone in the parking lot, talk to him extensively, and then come back into the courtroom.
There's no rush, Mr. McLean. I'm going to be doing a competency calendar and I have one other bench warrant matter that I'm going to address after the competency calendar. So you don't have to rush out to the parking lot whenever a phone's available. You can make that call.
Your Honor, they're not going to be available. Those are continuous interviews going on.
I see. Okay, well, then take your time. You don't have to rush out.
Okay.
A nice stroll outside to the parking lot will be just as good.
Right.
But I just wanted to confirm you have that number then?
4705348610.
Correct. Okay. All right, Mr. Rains, please hold on your Zoom. And then after you discuss the matter with Mr. McLean, and if you still would like to proceed and represent yourself, that is your absolute right. And so we will address that shortly. Mr. Rains, please go ahead and mute your screen. And the host will please correct the screen name to Tariq Rains, R-A-I-N-E-S. Thank you. Not last call, but one more call for William Thomas Harris. William Thomas Harris.
And Your Honor, I see on my laptop that he has been trying to contact me. I'm going to try to send the Zoom link again. He's having an issue connecting.
All right. No problem. So you go ahead and do that. And then meantime, Mr. McLean, let's see if we can complete the two other cases that we have on the calendar for you, or at least one of them. Position 21.
Pearson?
Yes.
No, that will be
no, that was Sean Tarver.
Sean who?
Oh, no, sorry, wrong calendar. Sorry, I'm flipping with different calendar. Position 21 is Tyrone Lindsay.
Let's see.
Okay. And Mr. Dotis, you are still waiting on position 15, right? Michael Herbert?
Yes, Your Honor. As soon as I see Mr. Herbert, I'll do a breakout room to speak with him.
Okay. Who's at 4 North?
I have Mr. Williams. I have Mr. Lindsay.
Oh, that's for the 11 a.m. calendar?
Yes.
Okay,
No. It's for the SAP right now.
Okay, who's seated next to you? Mr. Williams?
Yes. We was in the breakout session with Mr. McLean.
Okay.
And that's Pearson.
Pearson, Your Honor, is a not guilty arraignment, signature on request. We're ready.
Okay. So position 22 and 23, is that Mr. Pearson, officer at 4 North?
Yes.
Okay, so Mr. Pearson's case, Mr. McLean is indicating that he's entering a not guilty plea. Are you filing a waiver of arraignment?
We can do that, Your Honor. We can do that after court.
Okay.
But basically, the main point is that he's got a signature bond request.
All right, next person.
All right. So you are requesting that bond be modified for positions 25 and 26, correct?
Pearson, yes, 25, 26, correct.
Yeah, okay. So Mr. John Allen Pearson, case number 22 CR 6100G, in which he's accused of battery domestic violence. And the second case is 23 FTA 473, which is a bench warrant for failure to appear in court on December 2022. And this defense is asking that his bonds be modified to a signature bond. Mr. Jones, any comment?
Yes, Your Honor. The state would object to a signature bond. Just very briefly, the facts of this case involved Ms. Jasmine Jones, and she advised officers that her boyfriend struck her in the eye with a closed fist. Officers observed the victim's right eye was blacked and closed. In addition to that, Your Honor, Knight SC 169709 is a case where there's a ag assault. He pled guilty to applying pressure to this same victim's neck with his hands. He was sentenced to 12 months probation, 12 months probation with 24 months suspended. And that was on 10/15/2019. As Your Honor is aware, this incident occurred on January 31st of 2021, which means he would have still been on probation when this particular incident took place. In addition to that, the defendant has 27 total cycles, so Your Honor, and probation violations from 2003 and 2019. So Your Honor, we would object to a signature bond or anything along those lines, given the fact that, again, he was just convicted of he just pled guilty to an ag assault with the same victim as the victim in this case, and we're concerned with the risk of intimidation. So Your Honor, we would request that the bond stay the $5,000 cash bond.
Okay, and that would be really, I think, on the on his bench warrant as well.
Yes, Your Honor.
Okay, Mr. McLean?
Your Honor, the main points he'd like to make, he understands what his arrest record is, but am I correct in believing that this is a transferred intent legal theory according to the state that there was somebody else arguing and somebody swung a fist and hit her?
Your Honor, we aren't here to argue the facts of the case and what any potential defenses may be at trial. That's an issue that we can discuss further down the line. I believe we're here to argue the particular bond revocation. As I stated, the defendant took a guilty plea on October 15th of 2019, in which 12 months probation and 24 months suspended. So that was right after that this was yet another incident involving the same victim.
All right, Mr. McLean, that's your response from the state.
And Your Honor, he has worked for 5 years, the same car wash near or at Fulton Industrial. And Your Honor, he has not been in any contact with Jasmine Jones in the 2.5 years since then.
Okay.
I've also discussed with him ways of making sure that a court date is never missed by mail by not relying upon mail and having, if he were out of state at the time, the Kentucky address may have changed, but Your Honor, if he or a friend goes by the clerk's office and uses the public computer, which is there available for that purpose, every couple of weeks, it's impossible to miss a court date. You don't have to rely upon the mail. Or you can check the Fulton Daily Report. We had a full discussion on all that, and he is determined to never miss a court date. He is very apologetic that he did.
Okay. Mr. McLean and Mr. Jones, Mr. Pearson has another case, 21 CR 005961G. And that's a simple battery incident from April 20th, 2019, involving Jasmine Jones. And that case is before Judge Mather, and it's still open and pending. With regards to these matters, and especially in light of the fact that he's pled guilty to a felony case involving the same alleged victim, I'm going to set the bench warrant is not set aside. Position 26, I'm amending that bond to a $500 surety bond. No further contact with Jasmine Jones. With regards to position 25, I'm amending that bond to $2,000. That's a surety bond. I'm vacating the UJR and amending that to a $2,000 surety bond. No further contact with Jasmine Jones. I'm not sure where the $5,000 cash bond is, Mr. Jones. I don't see that.
Yeah, yes, Your Honor, that, 1 second. I may have misspoke on that one. I think that was noted if we had to make a bond request for an amount.
Okay, so for position 25, the UJR is set aside and vacated and amended to a $2,000 surety bond. No further contact with Jasmine Jones. That's JASMON.
JASMON, yes, ma'am.
Yeah. As I've indicated, he does have another open case, 21 CR 005961G. And the bench warrant bond is amended to a $500 surety bond. He's required to not consume any illegal drugs, no alcohol, no weapons, no firearms. And he's to update us with his any changes in his address, phone number, and email. And Mr. McLean, Since you filed a waiver arraignment, all three cases are going to be further notice for trial before Judge Mather.
Very good. Would Your Honor like me to prepare that bond modification?
I'll do that.
Very good. Oh, no, I got Lindsay.
All right.
So
Mr.
now I have
Pearson,
Lindsay.
all three cases are going to be reset for trial. You will get summons to appear in court. Okay, please unmute for North.
Yeah, I mean, that's what I want, but what I'm trying to see is what is really going on, because like that the one that was in 19, I did probation and I got done with that case. I got done because I paid off the fine and everything. So I don't see why that's even being put back up here.
I know I just saw that case, so.
Your Honor, the state's purpose for bringing up the 19 cases to show the history of violence between the defendant and the victim here.
I have not had no contact with her ever since then.
We've already made all those points. I think I can explain. If he needs a visit to explain the court's ruling, I'll be glad to do that.
Mr. Pearson, would you like to speak to Attorney McLean?
Yes.
All right, I think it would be best if you speak to him. I may have written down. Yes, I do understand, Mr. Pearson, as you've indicated, like you said, you have planned to have no contact with her at all, but that doesn't mitigate the fact that you do have open cases involving the same victim that have not been resolved yet.
But I don't see why that case is still open when I finished my probation for that. I finished off the fine and everything. And
I can understand. Okay, I just want to make sure which case that you did probation. So if you don't mind me, 21 CR 005961G. 21 CR 005961G. That case is still open and pending. You did not appear in court on February 16, 2022. Now, if you're talking about probation, it's possible that you completed your probation in the felony case in Superior Court.
Right. Okay, and my thing is, I have not even been in any trouble since then.
Understood, but you did not appear in court?
Yeah, that's because y'all sent the letter to Kentucky when I gave them my new address. And see, that's a mistake that they made. I mean, I got to suffer for that.
I don't know anything about whether you've updated your address. I don't know with whom you contacted.
I gave them my new address and I told them I stay in 2000.
Who is they?
I told the lady who did my signature bond. I gave her both of my addresses.
Who is they?
I don't know her name, but it was the lady who took down my information when I did my signature bond. I gave her all my information. I gave her the information to the addresses in Kentucky and the address in Atlanta.
You received a signature bond on September 12th, 2022. You received a UJR, if I'm assuming that's what you're referring to. February 21st was your. At that time, we had an address of 2009 Wells Drive.
Right, and I never got that letter.
Okay. Nothing was sent to Kentucky, if that's what you're asking me.
But they said it was sent to Kentucky.
I don't know which case you're referring to, Mr. North. You had multiple cases open. So if you can tell me which case you're referring to.
I'm referring to the last case that I got in trouble about. Because I got in a fight with my brother. My girl tried to break it up and she got hit by
All right,
accident.
now, Mr. Pearson, you want to discuss the facts of your case, and anything you say can and will be used against you. All right,
Be best if I spoke to him.
I totally agree.
Court.
Okay, I will do the bond order, so Mr. McLean and Mr. Pearson will discuss this matter with you, because I'm not getting anywhere with him. Thank you. I think that concludes all the cases on SAP for you, Mr. McLean.
Well, I have Mr. Tyrone Lindsay to speak to.
That's position 21. Okay, and you still have to speak with him?
Yes, Your Honor.
Okay, and where is he located?
Fort North.
All right. And Mr. Dodis, do you still have to speak to Mr. Herbert?
Yes, Your Honor. I'm not sure where he's located.
Francois, do you have any information about position 15, Mr. Herbert?
Francois. Francois. You know where Herbert is? She's asking. Judge Law is asking.
Position 15?
I have Mr. Herbert in Fort North.
At 4 North, okay. Mr. Dodis and Mr. McLean, both your clients, Mr. Herbert and Mr. Lindsay, are located at 4 North. So I can put 4 North in a breakout along with your laptop, and y'all can take turns to speak with your clients, and I can address those two matters after I complete my competency calendar.
Your Honor, since they're already pulled out of their cells, while one breakout is going on, I can fill out a visitation slip and run up to 4 North and speak to the other person in the visitation booth.
Whichever you're comfortable with, Mr. McLean.
I'll see Mr. Lindsay in the visitation booth in a few minutes.
Okay, I'll probably be done in about 15-20 minutes. Then I'm going to resume with this calendar and the remainder cases on my bench warrant.
Very good.
And Your Honor, before we go into the breakout room, can I address DV bench warrant 2?
Next person talking to this well.
Okay, what about Mr. Harris?
Yes, Your Honor. I've been in contact with Mr. Harris, and he's been contacting me since 10:30. He's having issues connecting his phone to Zoom. I believe his phone is too old for the Zoom app. I would request a 1-week reset for Mr. Harris to show up in person, which he said he can do.
Tell him to join via the phone.
Join by the phone? Okay. Is there a phone number I give him? My apologies.
No, on his Zoom link, he can just join by phone.
Correct, Your Honor. He's trying to do that, and I haven't been able to speak with him, but his text he's sending me to my laptop.
Where is he located right now?
He's in Valdosta, Georgia. But he says he can come in person.
All right. He needs to get on, find within the next 20 minutes, he needs to find another phone to get on the Zoom link.
Understood, Your Honor. I'll try and get in touch with him.
Thank you. Mr. Howard, I think I saw you appear. All right. And who is doing the competency matter with Mr. Howard and me?
I will be handling Owens, myself, and Deputy Lamar Rhodes, DSG Lamar Rhodes. With regards to any other competency matters, I'm not.
All right.
I believe Shelley, Deputy Falk should be joining for the competency calendar. I'll check for her whereabouts, Judge Law.
Okay. Miss, is it, who is Miss
Miss Champion.
Miss Champion, could you put me, Mr. Derek Howard, Mr. Howard, who's, is it going to be Kia today? Kasha right there?
Yes, Kia and Kasha are both on. If you can put them both in, Judge.
Kia Burgess and Kasha in the breakout with ASG Marquez Jones. And I think DSG Lamar Rhodes. In the breakout.
Mr. Murphy, do you have a client on the competency calendar today? Okay, I'll go ahead and put you in on the breakout room.
Thank you.
All right, they don't need you. They're gonna reset you another week. Yo, have a seat. Just to make sure, have a seat.
Hello?
Allison. Okay, you are still there. Yeah, sorry about that.
Yes.
I'll take that other call. Hey, Ms. Brown.
Hi, good morning.
So we're just waiting on the judge to return to the bench. She took a short break.
Sure. And so also I have included my supervisor. She should be hopping on, and just a matter of policy. She should also be hopping on shortly.
Sure.
Thank you.
Thank you.
Mr. McLean, can you hear me?
I can hear you. Who's speaking?
Officer Duffy.
Hey, well, let's
Do
see
you
which.
need- Do you need the ones that you spoke to back on the camera? Or I can take them.
I'm gonna tell the judge that Mr. Lindsay probably needs a conflict lawyer. And so she might want him to appear. I don't need Mr. Pearson at this point.
What about Mr. Owens? Are they,
Mr. Owens is not on my calendar anymore. He's on the competency calendar. And
Yeah.
Derek have him.
Derek would have, yeah.
Derek Howard would have him in the competency.
are they doing the competency right now?
I believe they are.
They are doing the competency calendar, and we've discussed Mr. Owens. I'm for sure Mr. Howard is going to want to tell him. So I'm not for sure if that's a breakout room situation or something along those lines. So we should probably keep him nearby.
Okay. Thank you.
No problem.
Hey, Mr. Jones, can you call me on 2-2392?
Give me the number again, I'm sorry. What was the number? I'm sorry.
I believe he said 2392.
2392. Thank you.
I believe that's what he said.
All right, we're gonna see.
Okay.
Okay, sorry, folks, our competency calendar is concluded, and I want to address ACDC if they are present. ACDC, Deputy Milton. All right, 4 North, who do you have? For North.
Yes, Mr. Owens, position 24.
Mr. Owens, okay. If you could start your video, please.
And Your Honor, that should be on conference, not the SAP calendar.
Yes, yes. Mr. Owens?
Yes, ma'am.
All right. Your attorney is Derek Howard. Can you see Mr. Howard on the screen? He's waving his hand at you. Do you see him?
No, ma'am.
Mr. Howard, maybe you might want to address
Hello?
it.
Can you hear me? Can you see me, Mr. Owens?
Oh,
You don't see me waving?
I see.
Duffy,
Okay.
Officer Duffy, can you point it out to him?
Yeah, he can see you now.
Okay, all right.
All right, Mr. Owens, I want just to let you know that your attorney has spoken to us about your case, and we are going to see you again on June 20th at 11 a.m.
Yes,
All
ma'am.
right? Okay, that's all I need to let you know right now. Mr. Howard will speak to you before then. All
Thank
right, thank you. For North, do you have by any chance a Mr. Schronhofer?
No, I don't.
Okay. Do you have any other cases at 4 North?
No, I'm done.
All right, thank you, sir. Thank you.
you.
Courtroom 2, and any updates on the cases you have from the SAP calendar?
Mr. Lindsay?
Mr. Lindsay, and Mr. Dotis, what's the situation with Mr. Herbert?
Yes, Your Honor, I'm going to request a 1-week reset with Mr. Herbert. I was able to speak with him, but because it is not his offer does have a substantial amount of jail time, I want to make sure that I'm properly addressing all of his concerns.
All right, his case is reset to June 22nd, next Thursday. And Mr. Lindsay is position 21.
Right. That accusation involved the name of another person who was on today's calendar, Mr. Fife, because it was a party to a crime. I think it would be best, Your Honor, he tells me that he has a private lawyer that represents him or has represented him very, very recently on a case that involves a 3-year sentence. Also, Your Honor, looking at his booking sheet, he has over $100,000 bond on another matter that is not this date. Given everything, it is likely that there's a conflict there somehow. We could analyze it. I'm not sure it would be worth the time to analyze his past cases and see when there are multi-co-defendant cases, but it would be, I think, best and cleanest, inspiring public confidence that the administration of justice is unbiased. We should appoint a conflict attorney for this one count, Mr. Rivas.
As party to a crime with Devin Fife, whom we've just addressed earlier today.
Now, he was represented by a conflict attorney as well, I believe.
Right, and he took a plea on a battery charge from the same date.
Right.
Okay.
But there are other cases that involve multiple co-defendants, and we'd have to go back and see if we represent anybody in those cases. So,
So you don't know whether you should represent Tyrone Lindsay as well?
correct. So we could go back and analyze those cases to see if we have a conflict and get back with the court on another day.
Okay.
Those are felony cases.
I'm going to reset this case 1 week to June 22nd. If you can reach out to Mr. Lindsay and let him know that if he has an attorney, that attorney needs to show up next week at 9 a.m.
Thank you. June what, Your Honor?
June 22nd.
Me too, gotcha.
Sorry, Judge Law, can you give me the reset date for position number 15 again?
June 22nd, next Thursday.
Thank you.
And position 21 reset to June 22nd for private attorney to appear. And I don't know who that is.
And it may be that he hasn't paid that attorney to work this case. So we'll see.
I hope that's not the reason. Okay,
And Your Honor, I was able to, for the DVBW calendar, I was able to walk Mr. Harris through the process of connecting to Zoom. He is on the Zoom as Samsung user. He doesn't know how to change his name, and I was
that's fine.
very
We can do
afraid
it.
to,
Okay,
do anything else.
so William Thomas Harris. All right, you need to unmute your screen.
Would it be okay to use the?
Yes, ma'am.
All right, Mr. Harris, you have a bench warrant in your particular case, if you just hold. First of all, you just need to be seated in one spot,
Yes, ma'am.
okay?
Yes, ma'am.
So, all right, thank you. And
Yes,
please
ma'am.
don't move the phone around because it's very distracting, okay?
Yes,
So
ma'am.
you're
I
good.
apologize.
All right, no problem, no problem. Just glad you were able to join us.
Ma'am, yes,
And
ma'am.
this is 22 CR 003-883E, State versus William Thomas Harris. Mr. Harris has been accused of battery, domestic violence from a June 7th, 2022 incident. It appears that he failed to appear in court on May 22nd, 2023. Judge Morrison issued a bench warrant, and his next court date before Judge Morrison is September 20th, 2023. All right. Mr. Harris, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and presently Mr. Angelo Dodis is representing you. I understand that you're presently residing in Valdosta, Georgia. Is that correct?
Ma'am, yes, ma'am.
All right. And you understand that you have an open pending case in Fulton County State Court.
Correct, yes, ma'am.
All right. Mr. Dodis, if you'd like to argue for the motion to set aside.
Thank you, Your Honor. Yes, upon his release back in 2022 for the underlying charge, Mr. Harris did not use an address that is no longer a good address. Since then, he has moved to Valdosta. From learning of the FTA, he did update his address. It is the address in Valdosta, Georgia, so that is a good address moving forward. Mr. Harris is clear that moving forward, it's his responsibility to ensure that the court is aware of any address or contact information changes. I've also provided him with information on going a step above and making sure that he's reaching out to ensure that there are any upcoming court dates. Mr. Harris is taking this very seriously. I know that he was late today, but he was trying since 10:30, and I was able to walk him through the Zoom appearance. He also did indicate that he was prepared to find a way to make it to Fulton County to appear in person if need be to address this. I have verified with him that, and he knows that for any in-person court dates, he will need to be in person if that's necessary. And he does assure me that he does have adequate transportation and will be at any future court dates. We would just request this court to set this aside.
Ms. Bickerstaff?
Yes, Your Honor. So this, we object to lifting the bench warrant. The defendant he's had 3 prior FTAs, 2 FTAs in Valdosta in 2014, and then he had a 2022 FTA in Harris County, Your Honor. So the state does not want to, and then he also has this FTA from last month with Judge Morrison. The state doesn't objects to lifting the bench warrant.
No objection. Okay. So, Mr. Dodis, we're going to set aside the bench warrant. Please indicate with the state's consent.
No, I object, Your Honor.
Oh, you object. I thought you said you had no objection.
No, I object. He has 3 other bench warrants, prior bench warrants in Valdosta, one in 2022. One in 2022 in Harris County and 2 in 2014 in Valdosta. And then he has his current one.
Okay. And he's got a hearing with Judge Morrison on September 20th as well.
Yes.
On this one. Okay. Mr. Dotis, your client apparently has a history of FTAs.
Excuse me, Your Honor, can I speak?
It's up to you and your attorney.
Mr. Harris, if you want, I'd rather speak in private, if need be. Your Honor, I don't have any information on any other cases in Valdosta. For this case, he does have just this one FTA. I don't see any current holds. I believe he's resolved all of his other matters. So we would just, and as stated, he has appeared before this court. He is taking this seriously. And
let's see now. What was the FTA case numbers, Ms. Bickerstaff?
I am looking for them. Hold on 1 second. Let me go. And I'm seeing it in the GCIC in Valdosta. So I do not have a case number.
In Your Honor, I concur. I'm looking at the GCIC as well. There are 2 cycles in 2014 where Valdosta police arrested this defendant for failure to appear, and one in June 20th of 2022 where the Harris County Sheriff's Office arrested him for failure to appear. He also has a number of probation violations as well, which all go to, for the state, overall belief that he is not going to follow the dictates of the court. And so that's why we are objecting. But no, there are no specific case numbers that are associated with those failure to appears, just the arrest cycles in the GCIC.
Okay. The accusation indicates that he was previously convicted of battery domestic violence. Is the state keeping this case?
Yes, Your Honor.
Okay. All right, Mr. Dotis.
Your Honor, nothing further. Mr. Harris knows what's needed of him in the future, and I'm confident that he will stay in touch and make it to all of his future court dates.
All right. Mr. Harris, I am not going to set aside the bench warrant. You have 7 days to travel to Atlanta, Georgia, and surrender yourself to the Fulton County Jail. I'm going to amend the bond to a $10,000 signature bond through pretrial services. I will allow for telephonic reporting to pretrial services once you are released from the Fulton County Jail. And your next court date with the Fulton State Court of Fulton County is with Judge Morrison on September 20th, 2023. Do you have any questions? Yes, sir.
Yes, ma'am. Yes, I do. Yes, ma'am. I do. I currently do. Okay, can I speak like briefly? Okay, when I got locked up in Rice Street, I got bonded out, right? But I got expedited to Harris County due to that charge, due to the battery family violence charge. I was staying in Union City. I was staying in Columbus. I would travel to Union City. That's how I got that case, and that's how I missed my court date. I was locked up in Harris County. From Union City, from you all's jail, from Fulton County, I got bonded out. I didn't get out of jail. I got expedited to Harris County. So when
were you released?
When I was released from Harris County Jail.
What date?
I was released in May.
What
May
date?
9th. May 9th.
May 9th.
I just got out of jail, man. I just got out of jail.
I know,
I
but you
didn't
do.
miss court on, I didn't miss court on purpose, Your Honor. I was locked up. When I got locked up, they sent a letter to the address. I was that old address. I was not staying there. That's not my address. That's my sister's-in-law address, Your Honor.
Okay, just a minute.
So when they
Just
told
a
me
minute.
about,
Just
yes,
a
ma'am.
minute, just a minute. The notice was sent to the 256 Oakley Road in Union City, Georgia.
Exactly. That's not my
Okay.
address, Your Honor.
Okay, that's fine, that's fine.
My sister, she bonded me out of jail, didn't report it and let them know that I had to be expedited to Harris County.
Did she let you know that she got the notice?
No, ma'am. Didn't
Okay.
know. I don't even know about. I'm just knowing about my day. I had to go to come to. I just had to leave. I just left from up there with you all.
Didn't
I
you
just
pay
had
a
to reset
bond?
my.
Did you pay a bond to
My
be
sister.
released?
My sister paid the bond. I was locked up, Your Honor. I was locked up in Union City in Wright Street County Jail. I got expedited to Harris County. Harris County came and got me. I had a hold over there for a traffic ticket. I sat in Harris County 4 months before I can get out of jail. And now I'm in Valdosta, Georgia. I didn't miss court on purpose. My court date got sent to that Oakley Road address. So I had to get in touch with the bondsman to see the bondsman to reset my court
Just
date,
one
Your
second. Mr. Harris, you can keep repeating the same information over and over again. Okay, I just want to know where we got the Oakley Road address from. So Ms. Champion, could you disallow the share screen rights, please, for me? You need to look at your screen, Mr. Harris.
I'm looking, Your Honor.
Ooh, what is this? Sorry, I have no idea what that is. So let me. Got a pop-up, okay.
Hello?
Just a second, I think, no, I don't know who's sharing screen. Somebody else sharing a screen? Okay, sorry. Ms. Champion, okay, let me see. Okay, there we go. All right, there we go. Got it right now. Mr. Harris? Did you switch off your
Yes,
video?
ma'am.
Okay, do you see the screen?
I'm looking at it, Your Honor.
All right. Do you see your booking information?
Yes, ma'am.
And this is the address that's provided when you were booked in.
Yes, because that's where I was picked up at, Your Honor.
No, sir, that's the address that was provided at the booking information. I don't know. That is not an address of the incident. That is the address that was provided, indicating that's your mailing address.
Yes, that is the ad. Listen, Your Honor, I'm not lying to you. That was the address I was picked from during the incident.
Okay.
During the incident, I got picked up from that address.
And when did you bond out? And listen very carefully, Mr. Harris, when you came out of jail,
yes, ma'am,
Harris County, did you come back to the court and update your address?
Did I come back to the court and update my address? I wasn't provided a court date, Your Honor. I didn't have
I'm not
a court
asking
date
you
around that
whether
time.
you got a court date. I'm not asking you for a court date. If you were not living at Oakley, when you were booked in, the Oakley address was provided. Once you were released from Harris County, did you come back to Fulton County and update us with your address?
I had to call I had a bondsman. I had to call the
The
bondsman.
bonding company is not your lawyer. The bonding company has no obligation to update the court.
If I'm locked up, how can I have any information, Your Honor? I didn't
I'm
have any
gonna-
information when
okay.
I got out of jail, Your Honor.
Your Honor, I'll,
Mr. Harris, no, I'm done. He's not listening to me.
I will call him and explain the situation.
I'm listening to Your
Okay.
Honor.
Mr.
I'm
Harris,
listening.
Mr.
Ma'am.
Harris, you have
Ma'am.
7 days to travel from Valdosta, Georgia, and come to the Fulton County Jail, where you will be processed through the intake division. After that, you will be released on a $10,000 signature bond through pretrial services. Do you understand?
Ma'am, yes, ma'am. So so basically I can sign myself out.
Correct. But you will be required to report to pretrial once a month by telephone. And anytime you change your address, your contact information, you will update the court immediately. You don't go through your bonding company. You don't go through somebody else. You will contact the clerk's office and make sure that we have your correct address. Do you understand?
Ma'am, yes, ma'am.
Your next court date, in case you want to write it down, just to make sure that you have that, it's going to be on September 20th, 2023 at 2 p.m. in courtroom 2F at the Fulton County State Court. Well, I guess you're not writing it down, but I guess you'll commit that to memory.
I got a good memory. I ain't forget my Zoom.
Well, that's good. All right, we will see you. Please understand that you have until next Thursday before 5 p.m. to surrender to the Fulton County Jail at Rice Street. Thank you.
Can either Mr. Jodas or Mr. Harris put his phone number into the chat for me, please?
I'll put it in the chat. Mr. Harris, I'm gonna call you shortly, okay?
Thank you.
All right, moving on back to Mr. Robert Lee Bonner.
And Your Honor, we did address Mr. Bonner's bench warrant that was set aside. I believe we just have position 3 on the bench warrant.
Oh, position 3, I'm so sorry. Yeah. Mr. Tariq Rains.
And Mr. Harris, you can leave the Zoom. I'm gonna try to give you a phone call right now.
Is Mr. Rains still with us? Yeah, he is.
Should be.
Okay, now, Mr. Rains, are you driving?
No, I'm parked.
Okay, please remove your shades. Thank you.
I'm sorry.
Okay. All right, so Mr. McLean, is this your client?
Well, Your Honor, he could go pro se or he could be our client for right now. Either way would be fine. This will be a brief matter in that we got hold of the pretrial release folks and they're going to state whether he appears to have been given notice or a reminder from them rather. I know that he's responsible, of course, for keeping up with court dates and give free advice to anybody about how to make sure that you don't have to rely upon the mail. But Your Honor, apparently he didn't know about this particular court date, and I believe Ms. Brown and her supervisor are on Zoom.
All right, thank you. Mr. Rains, so last time we got off with this hearing, I wasn't sure if you were represented by the Public Defender's Office. So again, I'll remind you, you have a right to remain silent. Anything that you choose to say about the circumstances of your case, your statements can and will be used against you. It appears that Mr. McLean's indicated that the Public Defender's Office will represent him. Was that correct, Mr. McLean?
For right now, that's fine, Your Honor, yes. Now, in the future, being out, if he has adequate income, he may not qualify, apparently.
All right, but we've not evaluated him to see if he qualifies?
I believe he has been evaluated in the past, and I think it was a DNQ. I think it probably was a DNQ. Because not qualified.
Mr. Rains, were you evaluated in the past by the Public Defender's Office to see if you qualified for the Public Defender's Office?
Yeah, I had filled out a piece of paper and Charles Ford sent it back, said I didn't qualify.
And what was the response from the Public Defender's Office?
I believe he said I made too much, but I don't see how.
And do you make the same amount of income as you did the last time that you applied?
No.
Okay. All right, Mr. McLean, I'll let you remain as his counsel unless you pre-qualify him for services down the road. So he's accused for having failure to appear in court on May 16, 2023, before Judge Dixon, and a bench warrant was issued. So what would you like to tell us, Mr. McLean?
Right, as the phrase goes, to cut to the chase, I believe Ms. Brown and her supervisor may have some information about reminders.
Hi, good afternoon. I'm Mr. Raines, pretrial release officer.
All right, Ms. Brown, if you'd like to raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Yes, Ms. Brown.
Yes, so I'm sorry, I was under the impression I was addressing the hearing from June 8th. However, on about the 16th, it looks like a notice may have been sent on the 1st of June. I did send Mr. Raines to the clerk's office to request to set aside, update any information that he may have needed. And it looks like this may be a matter of an updated address based on the document that that was attached. However, I don't see after that where a notice was actually sent to Mr. Raines.
He was required, yeah, it looks like he didn't appear for Judge Dixon, and then the case was on June 8th and it was reset.
Yes, that's what I see on my screen. Yes, ma'am.
Okay. Ms. Bickerstaff, do you have a comment?
So I'm a little confused. So are you saying that pretrial did not send him the notice for the May 16th date that he didn't appear to?
Pretrial doesn't send notices. That typically will come from the litigation manager.
Well, did he get a notice?
Mr. Raines, did you receive the notice?
No, ma'am. And I checked my email for Fulton County for everything, and I have no receipt since 2022.
And for the address, I have that it was sent. Well, he did get a notice on May 1st, and the address, I'm sorry for asking that. The address that I have is 3379 Hallwood Circle in Macon, Georgia. Is that the correct address?
Mr. Raines?
It was, but my address where my mail is sent is 1173 4th Avenue, because when it gets sent to 3379, my mail gets mixed up with other people's mail. So I have it just sent to my address where my license is, which is 1173 4th Avenue, where all my mail is sent, where I can get informed delivery. But nothing was sent in regards to where, because they usually send it via email as well. So that's why I was looking via email more so. So it wasn't sent there. So I may have missed it in the mail. And then I went down there to change my address so they knew that if anything else was required from me, they can send it to that address where I needed them to send it.
Well,
So
Mr.
I did.
Raines, notices are sent by mail. And if you look at your screen, that's the two addresses we have.
Which one?
Look at
See,
your-
I didn't get anything to send to 1173 4th Avenue.
Well, the address, it was sent, Your Honor, it was sent to, the notice on May 1st was sent to the 3379 Hallwood Circle. So the state's position is to keep the bench warrant. We object to removing the bench warrant.
Mr. Raines, do you see the two addresses on the screen?
Yes, ma'am.
All right. First of all, let's you and I get one thing clear. You don't schedule court dates. All right?
Yes, ma'am.
Number two, you provided us with the 3379 Hallwood Circle, Macon, Georgia. So that's the address that we send notices to. You don't get to pick and choose which address notices are sent to. Do you understand?
Yes, ma'am.
You are the defendant charged with a crime violating a law in the state of Georgia. You don't get to dictate how a court manages its case.
Yes, ma'am.
All right? The arrogance that you initially displayed was sufficient for me to say, go ahead, execute the bench warrant, have you brought in from Macon and stay in jail. Do you understand?
Yes, ma'am.
All right. Right now, the address we have is Hallwood Circle. If you have a problem with your address, that is not our problem. That's your problem. If that is the incorrect address, you are required to come down to court in person and amend it to the address which works.
Yes, ma'am.
I want the correct address reflected on the screen in our court system by next Thursday, June 22nd, 2023.
And where would I have to go to make sure that happens, Judge Law?
160 Prior Street, Suite
Mhm.
J150. You need to bring your case number and your ID.
Yes, ma'am. I'll make sure I'll be there. Can I be there by tomorrow?
You can be there by tomorrow. The deadline is by next Thursday.
I'll make
I'm
sure it's
going to
in by
set aside-
tomorrow.
I'm going to set aside the bench warrant, but you are required to make sure that you show up at the clerk's office by next Thursday and update us. The next
Yes, ma'am.
time you don't get notice in the mail, let me make it sure that's on the record. It's
Yes,
your
ma'am.
complete fault.
Yes, ma'am.
All right?
Yes, ma'am.
Now, while you are here to make sure that the address is updated, you might also want to maybe drop a visit to the Fulton County Public Defender's Office and make sure that you apply for to see if you qualify. If you don't qualify, then it's your option of whether you want to hire a private attorney or represent yourself. I would highly recommend getting counsel because your behavior through this Zoom proceeding doesn't give me a lot of confidence in your ability to represent yourself. Thank you. Mr. McLean, would you like to submit a proposed order?
Yes, Your Honor, we'd be glad to.
Thank
It
you.
sounds like if there are changed circumstances that may affect the future as well. We
All
would
right.
submit that, Your Honor.
All right, thank you, sir. Thank you, Ms. Brown. Appreciate you coming in and chiming in.
Thank you so much for having me. Have a good day, everyone.
You too.
Thank you.
All right,
Okay,
thank you.
folks, that concludes our DB bench calendar and position one on the DB bench calendar. I think Mr. Dodis is sending the proposed order. Position two, I'll go ahead and do that. And position three, Mr. McLean is sending in the proposed order. Do I need to go over the SAP calendar again, or are we all good?
We have everything, Your Honor. If the state.
Okay, Ms. Bickerstaff, we good?
We are good, Judge Law.
All right, folks.
Can you send over all paperwork to melissa.grace@fultoncountyga.gov, please?
Understood, Ms. Grace.
Thank you.
All right, everyone, y'all have a pleasant afternoon.
No.
Mr. Dotis,
No.
don't forget to send me Mr. Harris's phone number in the chat, please.
Let me do that real quick. My apologies.
That's okay.
All right, before Ms. Champion closes out the proceeding, Ms. Champion, you can go ahead and pause the recording and live stream.